So good morning. I'm Dave Katner from the Tulane Law School, and I want to thank all these lovely people for coming out today. This is actually the best kept secret we've had at the law school for the last week or so. So there's plenty of food for you guys to enjoy. The program that, or at least the presentation I intend to make, deals with actual provisions from the American Bar Association's Model Rule 1.14. And if you think that that topic sounds drier than or worse than watching paint dry, you're right. So I figure we kick it off with representing crazy clients, the legal ethics perspective. This is a topic that's near and dear to my heart. So for about 30 years, I've been writing on different aspects of the work that I do in the representation of people. And as anecdotal background, for about 7 years, I handle all the insanity defenses in the Jefferson Parish court system in the 24th Judicial District Court. And for about 9 years, I did all of the involuntary commitments in civil court. I've also done a lot of medical malpractice litigation, but I've also done hundreds of challenges to client competency. And for years, my telephone number and name was etched in stone, literally on the fourth floor of Charity Hospital, which is where the lockdown division is for people who have mental health issues. So we would get constant phone calls from people seeking to get out of a lockdown facility at the largest public hospital in the South. The issue from a legal perspective is a little strange and a little unusual because about 42 years ago, the ABA drafted a rule entitled 1.14. And the thinking behind the adoption of the rule was to give us, by us, I mean lawyers, a sense of direction as to how to go about providing competent representation for people who may have diminished capacity, who may not understand the nature of the legal issues that are facing them. So one of the concerns that I've had is how do we identify people who may not have that competency? And when we tend to think of people who have any sort of disability, mental disability, or we think of people who may be having acute issues, so we tend to exaggerate and think of people that we're familiar with, I guess, from mass media. So I thought the use of Jack Nicholson in The Shining was appropriate. The concern, though, is that this is such a misrepresentation of what clients look like who lack competency. This, of course, is done for theatrical purposes, and this has nothing to do with the representation of people who lack competency. The vast majority of people who lack competency are going to look like anyone else in this room, with the exception of me, because you'll see me coming a mile away and you'll think, oh, that guy, he's going to be trouble. But for the rest of you, you might look just like any of the other clients that I've represented who had really serious mental health problems. Sometimes they're going to be telltale signs. Sometimes the telltale signs are behavioral. Sometimes the telltale signs may be anomalies in their face, or it just might be some behaviors that are just so profound that you'll not be able to not to notice. But for the vast majority of people from adolescence on into adulthood, that's just not the case. One of the things that I think is crucial to have a sense of understanding is the actual language that the ABA drafted and who drafted the language. So again, this goes back 42 years. Now, for many of you in the room, you may not have been alive when this rule was being drafted. That would not be terribly surprising. But the notion that we take a group of white lawyers from major law firms and put them in a room for 3 days and have them devise a rule that governs our ethical conduct, this is where we were in the legal profession, and this is where we were 42 years ago, but it's actually where we've been probably up until, oh, I don't know, today. And the consequences of having this small elite group of people working on putting together our ethics code, there were many things that they did and they've done, I think, a masterful job of. But there's so many things that really need to be revised and revised on a really substantive level. So the language in 1.14 is when an attorney represents a client with diminished capacity, counsel shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. Okay, for over 40 years, I have been troubled by the use of what a normal client-attorney relationship might be. So let's assume for a moment that I represent people who have been civilly committed. My normal attorney-client relationship is interacting with people who may be completely incompetent. It may be people who are showing signs of schizophrenia without medication, bipolar disorder, serious depression, who are having hallucinations. Those are my normal clients. That's what I do on a daily basis. That's my normal attorney-client relationship. But let's assume that you do transactional law for a living. And let's assume that your normal relationship is interacting with someone from a brokerage firm or a bank. Our concept of what normalcy would be in terms of how we practice law, I think would be widely different. And I think that the phrasing here did not anticipate the nature of the way that the legal profession was moving forward, because each year that goes by, the work that we do becomes more and more limited, becomes more narrow and more focused. And I think that when we begin to see that large numbers of large firms continue to subdivide, and they'll have lawyers working on one small aspect of legal problem solving, which means we have to have a much more wide and much more diverse group of attorneys under the same roof. The same is true not just for large firms, but medium-sized firms as well. The concern then is, how do we define normalcy in the attorney-client relationship? My proposal is very simple. We have to jettison the language of this rule. It's legally binding. If you live in a state that has adopted the provisions of 1.14, it is legally binding on you to comply with these rules. Now, who doesn't believe in the notion of legally binding ethics rules? I would say Rudy Giuliani, John Eastman, Sidney the Kraken Powell, Dana Ellis, Jeff Clark, and even Kenneth Chesebro. These are people who don't believe in the concept that ethics rules can be legally binding. Now, in all fairness, all of them have either been indicted, sanctioned, or disbarred. And so I think that this message is coming home to them, and we owe these pioneers a debt of gratitude for sacrificing themselves so we can use their example to train the next generation of lawyers, that we need to pay more attention to the application of these rules. If you look up Rule 1.14, you're not going to see a plethora of legal decisions that have been written about this, because no one ever files complaints against their lawyers for violating 1.14. And the question is why? Well, first of all, this is a paternalistic paradigm, but it's a paternalistic paradigm that really knows no equal. This is a paradigm in which we vest discretion solely to lawyers to make a determination whether a client has diminished capacity. Who better to make that decision than people who were trained in law school? Because, as you know, we offer a wide variety of courses. In fact, we actually train you how to determine whether people are mentally ill, how to make determinations as to whether or not people who might look like Jacqueline Nicholson or who might look like you, how these people are dysfunctional. And then when you stop thinking about members of your immediate family and make a broader perspective in terms of how that dysfunction manifests, you begin to think, why and how should we be entrusted with this decision-making capacity? If we were to think of how successful lawyers are, just in terms of their daily lives, I will tell you that when you look at statistics involving domestic happiness, that is divorces and such, that we rank near the top of professions in terms of successfully ending our relationships through the legal system. I'm sure that we do it solely for the purpose of giving more work to even more lawyers, because we're generous like that. But what if that's not the motivation? What if the motivation is actually that we're really bad partners, that we really make poor decisions, and that we really cannot maintain and uphold our oaths? My suspicion is it might be the latter rather than the former, but that's just speculation. If we think about the number of lawyers and law firms who file for bankruptcy relief, I think that we're not quite yet up to the level of our former president in terms of his success with the bankruptcy system, but we are coming close and approaching that, which would suggest that we are not the best people to manage our own money, let alone the money of other individuals. And yet, if we challenge a person for diminished capacity, the vast majority of jurisdictions around the country are going to appoint someone called a guardian ad litem, a GAL. Who are these GALs? What gifts are they there to bestow upon the individuals who may suffer with diminished capacity? Well, of course, they're lawyers. And why would they not be? Because lawyers are so good at managing their personal affairs. Or maybe not. The reality is that, once again, we have a group of white male lawyers in a room with no windows, probably smoking cigars and drinking God knows what, and coming to a conclusion that this is the way the system should work. We don't have to work with people with diminished capacity. That's going to trickle downhill, and that's going to be left up to the associates, and we're not going to keep them forever anyway. So we have a concept in which we at least want to pay some recognition to the idea that some clients, under some circumstances, may have diminished capacity. I would argue that that's probably a complete misrepresentation of our reality today. When we begin to look at statistics that are available on PubMed, and we begin to think of the publications that are coming out of the American Psychiatric Association and the American Forensic Psychology Association, both organizations are saying with great alarm that percentages of people who have diagnostic conditions, and by diagnostic I mean conditions that are identified in the Diagnostic and Statistical Manual 5TR, that's sort of the Bible for people who do mental health work, that the percentage of individuals with these diagnostic conditions continues to increase almost every year. Why would it not? If we have 2 years to 2.5 years of isolation from a nationwide or worldwide pandemic, the idea of suddenly having people who once had social lives become complete hermits for a 2-year time frame, and God forbid you don't have kids, because if you do, then you will lock yourself up in your house with your children. So if you weren't crazy before the pandemic and you have kids, I can assure you that the likelihood that you're now crazy, that there's a very strong possibility of that. But those aren't the people I'm concerned about. The people I'm concerned about actually are individuals who are involved in the legal system. And who are they? They're everyone. They're everyone. And this is not something that is restricted to children. This is not something restricted to adolescents. It's not something restricted to young adults whose amygdala have not yet developed. This is a wide, vast sea of possible clients. When Mr. Benson was having some problems with his health, members of his family who love him dearly decided to file multiple lawsuits in an effort to try to assume full control over his finances. The one person who stood in their path was his wife, Gail Benson. After about 3 months of litigation, again, this is very helpful for members of the legal profession, the conclusion the judge reached was that Mr. Benson was completely sane, of sound mind. He, in fact, is the owner of the Saints. That might make you think, well, how could he be sane given the fact that he owns the Saints and he's responsible for the people that we draft? Tonight is the draft night for the NFL. I know some of you are itching to get out of the room so that you can go start watching the pregame draft program. The concern, though, is we have financial motivations that might be an incentive for individuals to challenge people and to make accusations that those people are not competent, simply to gain control of their money. One more factor about the development of the ABA Rule 1.14. When I look for the history, and there's actually something entitled A Legislative History of the Development of the ABA Model Rules of Professional Conduct. So for those of you suffering from insomnia, this will absolutely provide you with a sure cure. And this history essentially is a series of lists of who was present, when, where, and what they did. I was really interested in knowing who were the lawyers who showed up to craft the language of 1.14. And lo and behold, first, it was all men, of course. Of course, it was all men. Secondly, they were all connected with large firms. Of course, they were connected with large firms. Third, and most importantly, there's not a single person who has any training in mental health at all who was involved in crafting the language and the law involving diminished capacity. So where does that leave us? I think it leaves us in a position where it's time to open up the ranks of drafting our legal ethics rules, but particularly this legal ethics rule. What is diminished capacity? Would it be something that we ascribe to a client who names his newborn child after an algorithm? Now, that would be Elon Musk, and I think some of you will agree that there could be reason to challenge Mr. Musk's diminished capacity. Would it be a client who only speaks in tongues? I actually represented a guy in criminal court who was charged with murder. He claimed to only speak in tongues. We had a brief conversation. A small miracle occurred, and he regained his ability to communicate in English. A client who doesn't speak at all. I was in trial 2 days ago with a young lady who does not speak at all. She's very high functioning. She will not speak. There's some sort of trauma exposure there. I don't know what. A client recovering from a stroke, a client suffering from dementia, from Alzheimer's disease, a client with fetal alcohol spectrum disorder. We know from national studies coming out of both Canada and from Australia that 1/3 of all the children who are locked up for an indefinite period of time in their jails are now being diagnosed with FASD. Not one lawyer in thousands of cases ever challenged the competency of those children before they went to trial, before they were convicted, before they were sent to spend years of their lives in lockdown facilities. Today, we're using interdisciplinary teams, at least in other countries, not in the US, and we're focusing and determining the high level of this type of dysfunction. This is a condition over which these children have no control. They have no say in the matter, and there's really nothing they can do about it. What about a client who's diagnosed with bipolar disorder and who's off their medications? What about a client who claims that they're outer space ray guns that are changing voting machine votes in a presidential election? I don't know about you, but I think that there are any number of companies, particularly Dominion and Smartmetric, that would offer suggestions that people who do that are either not competent or they're committing acts of defamation and they need to be sued. I think both of those might be true. So the upshot is when we think about diminished capacity, there's a holistic perspective that we don't really think about. And I guarantee that that's not what I think was on the minds of those group of lawyers who mostly represented elderly clients. Why were elder law lawyers involved in the crafting of 1.14? Well, first of all, they have a financial incentive in terms of how to craft the ethics rule, because they don't actually represent necessarily what is right or what is best or what's in the interest of the elder client. They represent, more often than not, whatever the issues are for the people who are paying them. And I'm not trying to demean the lawyers who work in this field. There are many honorable people who work there. The concern is when drafting this rule, we drafted a rule that basically still vested all control and all autonomy in the hands of the lawyers. The lawyers who have no health background, they have no treatment for mental health issues, they have no ability to recognize any of these factors that I've listed, no more so than you or I have. And honestly, the only reason I recognize it is because I've worked with people with such issues for I guess, 45 years now. Usurping client autonomy. What does the rule allow us to do? The client suffers from a debilitating condition resulting in constant, excruciating pain. We'll call the client a burn victim. The client wants to take their own life. Is that an indication that the client lacks competency? Because if you say yes, I would say you've never been to a burn victim. You've never been to any of the locations in hospitals where they treat burn victims. They're usually in facilities that are separate and apart from the rest of the hospital. And you can only imagine why that is. Having represented a number of people who have been severely burned, I can tell you, these are not places to bring little children in to be entertained in terms of how lawyers get along with their clients. These are horrific scenarios in which people have to attempt to survive. What about a client who has auditory hallucinations? Someone who's diagnosed with Alzheimer's? Again, what this rule does is it allows the lawyer to usurp the autonomy of these individuals. My suggestion is that may not be the best way of going about providing legal representation. What about a client who's simply unable to communicate? Well, there are many reasons why people may not be able to communicate. It may be that they're overdosing on their medication and they need a doctor to rewrite whatever the prescription is. It may be that they have a head injury and that they're not able to function today, but let's wait a week, let's wait 3 days, let's wait a day, maybe wait 2 hours, and they may be perfectly capable of communicating. So we have different types of behavior. If you look at a continuum and you say that there's certain people who are simply not able to communicate with their lawyer, they are not capable of making decisions, and there's no reason to believe that they're going to improve. That's a tiny sliver of people, I suggest, who may have diminished capacity. I think there's a massive percentage of people who fall into this category. And again, this is not restricted. This is not restricted to people who are simply poor. There's a lot of literature about this article, and most of it focuses on that thinking that the majority of clients who are not competent happen to be poor. I do not share that perspective. I think that these are people who get caught up in a trap and that they become more notably identifiable than the rest of society, because the rest of society has private insurance and they can make appointments to go see psychiatrists and psychologists and social work therapists. The poor generally are not having the ability to do that. Professional training to diagnose or assess mental illness. Look, we know we don't do it in law school. Contrary to what I said in my introduction, we just don't provide any training to allow people in our profession to make these types of assessments. We don't have any licensure to make these assessments. We're not trained to identify symptoms. How do we even identify people with FASD? We have physicians today, we have pediatricians who have no clue how to make that identification because it's only been something that's been identified for 17 years. And it's not something that is necessarily taught in all medical schools. So we have an elephant in the room, we have a gorilla in the room, and we're trying to figure out how to cope with something that we have been intentionally, I think, negligent and ignorant of. We don't know how to go about exposing client histories. We don't even attempt to do that. If you're an elder lawyer, what you want to know is there money in the estate, and is there going to be enough money to hire my law firm or to hire me? And I think that pretty much sums up part of the motivation of the folks who were involved in crafting the law. Again, I'm not saying that we shouldn't get paid for our services. I am saying that we have our own conflicts of interest if we're the people who are drafting an ethics rule that applies in a much more broad application than just representing people who have a lot of money and who are elderly. We can look to forensic mental health professions who actually do have assessment tools for clients. And the ABA worked with the American Psychological Association, the National College of Probate Judges, and they put together this really neat little book. It's only about 40 or 50 pages called Judicial Determination of Capacity of Older Adults and Guardian Proceedings. The amazing thing about the publication is the charts that the forensic psychologists came up with are really easy to read. You don't have to have a degree in psychology to understand the nature of the charts. You don't have to have a background in medicine to be able to interpret this. This was written to help lawyers, so they knew their audience when they wrote this pamphlet. We have never attempted to incorporate any of the data in a joint interdisciplinary project such as this. My proposal is simple. Let's go back to the table. Let's open the doors. Let's get some nice food offerings in the background to entice people to show up. That's the only way we work in law school. And if we are able to bring forensic experts into that conversation about our ethical application, the question is, how do we go about making those assessments? And that's the issue, and that's the purpose of the article. So, these clients don't need us to usurp their autonomy. These clients don't need us to make decisions in their behalf. These clients don't need us to make a diagnostic impression, something that we have no competency to do. They need us to stand by them. They need us to assist them in making the decisions as autonomously as they're able to. Not for everyone, but for some. This rule doesn't even provide us with that opportunity. We can have interdisciplinary teams to react and to rethink how this rule should be applied. The paper is intended to start the conversation. I'm happy to give particular specific proposals. It's written in the paper. I'm sure that if you thought that this book would help to cure your insomnia, wait till you read my paper. That'll do an even better job. Thanks for coming out. Enjoy the food. And please don't tell anyone else about this program today, because when they find out that faculty members are turning tricks for the university, they're going to go absolutely crazy. Thank you very much.
Hi, everyone. The few of you who are still here, good morning. TRICS stalwarts. So I'm presenting a paper that was, I've recently finished up substantially and submitted for publication this past spring cycle. It's called Shamed. It's forthcoming in the Virginia Law Review. And the introduction to it might feel a little bit familiar because I talked about my last paper, Ruined, and then kind of trailed off with my thoughts about how to start this paper, Shamed, last year. So it's nice to be able to come back and be able to talk about it in this venue. You might notice that I actually have QR codes because I wasn't sure how many people would be showing up. You can actually scan the QR code and it will take you to SSRN, where you can download the paper. You will also see QR codes throughout the presentation with regard to artworks. It will take you to a page that will tell you a bit more about the artwork that I am referencing. But to talk a little bit about art here, when I was a teenager, well, let me start off talking real quick about the last paper. And I should give you a content warning too. The presentation is going to discuss sexual assault and rape, victimization, violence against women in descriptive terms, as well as in imagery. So just to give everyone a little bit of a warning. But again, this is a bit of a follow-up on the last paper that I wrote, Ruined. Again, here's a QR code in case you wanted to download it. But when I was a teenager and continuing on to college, I really liked to spend a lot of time in museums. And at one point I got an internship at the Getty that was meant to give students from underrepresented populations in art education and curatorship the chance to gain more experience and connections in those fields. I thought that I might want to work in an art museum one day back then. So I got to spend a lot of time at the Getty Center, which is where this painting lives. This is a depiction of Lucretia painted by Artemisia Gentileschi somewhere around, circa 1627. As depicted by Gentileschi, Lucretia, she's obviously a noblewoman of some sort. She's wearing pearls, not just in her earrings, but she's got strings of them in her hair. She's got this really sort of nice diaphanous sort of silky fabric. She's got this knife that she's pointing at her chest, which if you're able to look at it really closely, the hilt is made of gold. It looks like it has a rabbit head as decor at the end with like little ruby eyes. So she's obviously someone who's really, really important and wealthy. Lucretia was the faithful wife, at least according to Roman legend, of Lucius Tarquinius Collidenus, and was raped by Sextus Tarquinius, the son of the king of Rome. And she called on her father and her husband to exact vengeance for this wrong, and then afterwards stabbed herself to death, so the legend goes. It also goes on that this anger over Lucretia's death led to the fall of the Roman monarchy and the establishment of the Roman Republic, because of course that's the important thing to take away from this terrible thing that happened to this woman, right? So there have been many depictions of Lucretia over many hundreds of years, yet this depiction of her by Gentileschi is the one that I, as a rape victim, have always found the most relatable. And it focuses exclusively on Lucretia and her anguish rather than the political ramifications of her death. So perhaps this empathy with Lucretia's plight on the part of the artist makes sense, given that Gentileschi was raped as well by artist Agostino Tassi when she was 17. So Tassi initially promised to marry her as if that fixes everything, right? But he later refused, leading Gentileschi to finally report what had happened to her father and leading to a 7-month trial during which she was put to thumb screws to testify because apparently that would make her more truthful. So while being tortured during the trial, she purportedly yelled out to Tassi, behold, this is the ring you gave me, and these are your promises. So, maybe, today's reader might look at these stories and think that they sound really remote and archaic and kind of like Baroque, right? But there's been a long association with rape victims being tortured, rape victims being harassed, rape victims being shamed, and even leading to a long association with rape victims and attempted suicide, and those reporting histories of sexual assault also having an elevated risk of that as well. So at least by one estimate, rape victims are 4.1 times more likely to contemplate suicide, while they're 13 times more likely to attempt suicide. So rape victims, are tormented in a number of ways when they come forward and testify against the person who did them harm. Nowadays, if they don't want to be testified, you might even see them getting locked up in jail by the local prosecutor until they do so, or what have you. In much more public fashion, they might, if they do testify, they might end up getting very widely shamed in public. And this clicker does not work. So here's an example. From the E. Jean Carroll rape civil trial, right? So Carroll, was able to very bravely come forward against Donald Trump after decades, right? Was finally able to do this. And she was asked in court why she stayed silent, and she said, "I would never report something like this. Roger Ailes would have fired me. He was a friend of Donald Trump. I was ashamed. I thought it was my fault." She went on as to why she didn't report, as a lot of people somehow think is super logical to do, immediately after the rape happened. She said that people view women who are sexually abused as soiled goods, and people say, you're so brave, but also, I don't know. questioning whether the woman should have been smarter, should have screamed, shouldn't have flirted so much. So the title of my previous article addressing language used during sentencing in sexual assault cases by judges is titled Ruined. It has quotation marks around it. That is very intentional. And that's because while judges might want to pronounce rape victims as being ruined, it's the job of the victim themselves who should, they're the ones who should be allowed to determine and pronounce their own fate after something like this happens to them. The title of this paper, though, is Shamed. And I dispense of the quotation marks, not because victims should be ashamed of the harm that's happened to them, because attempts to shame victims are real. They happen all the time. They're pervasive, they're harmful, even when it's not immediately apparent. So shaming of sexual assault victims exists in police investigations, courtrooms, interpersonal relationships, and it's to some extent, I would argue, even written in the law. Even when you're talking about interpreting the law of sexual assault, as Robert Cover has previously explained, interpretive acts on the parts of judges are themselves violent deeds that authorize and legitimate the law. So because that legal interpretation depends on the social practice of, violence to be effective, all manner of violence is happening when we're talking about the law. So this article considers the existence of shame and its operationalization in relation to rape and sexual assault. And I talk about shame and why it occurs a bit more largely, just a larger societal level, even going into a brief introduction of just world theory, which posits that most people, to some extent, believe in a world where good things happen to good people and bad things happen to bad people. Life, I think, for a lot of people just doesn't make sense otherwise, and sort of the ramifications that come of that. But also in this paper, I look at three main avenues for shaming that I feel like haven't been covered all that much. I look at shaming, of course, in the criminal legal system. There are a lot of people who've written about victim shaming in the context of trial. I actually keep it exclusively to adjudication because a lot of these articles about trial don't seem to acknowledge that most criminal law cases don't go to trial. They end up settling, and a lot of people aren't looking at that. So I think there's rather scanty literature with regard to victim blaming and shaming in the confines of criminal adjudication, which honestly I have a big passion for. I teach criminal adjudication. It's a subject matter that I love. So trial, again, seldom happens, and the vast majority of criminal cases are resolved without a trial. I look at shaming in the context of the legal profession. I also look at shaming that occurs in academia. So just to give you a little bit of background, from what I've learned researching for this paper and getting prepared for it, legal scholarship seems to conflate what stigma and shame are. No surprise, lawyers are really bad at dealing with these really complex sort of psychological issues and terminologies, I think a bit as Professor Catler was talking about immediately before me to some extent. So stigma can be thought of as the social devaluing of a personal attribute, and is only going to exist in a specific social context. So this is then generally categorized into discrimination and internalized stigma. So it's this sort of stigma, whether external in the form of some sort of discrimination of some kind or internalized, that can lead to a person feeling shame. Shame is a negative self-conscious emotion triggered when people experience failure in regards to personal or social standards that are determined by dominant social groups. So it's a reaction that can be found across cultures and classes. It's universal, it's an adaptive and common emotional response. And in this sense, one can understand shame as the result of stigma, right? And the process, of stigmatizing a certain characteristic or an experience or an attribute as, the engaging in shaming itself. Shaming a person or a group of people is stigma put into motion, for lack of a better way of putting it. So there are three avenues of shame that I feel like legal scholars haven't really delineated from, one from each other until this paper, and actually, honestly, until the last TRICS, when, I was talking about these and trying to figure out how to group these, and Anne actually gave me a really great sort of way of organizing this that I've run with and for which I will always be eternally grateful. There's the shame that victims are made to feel, such as, people just not belonging you, people asking what exactly it is that you've done wrong. The shame that rape victims are supposed to perform. For example, when you prosecute one of these cases, you might have a victim who's told to make sure that they dress modestly when they come to testify, or that maybe they should learn to tell their story in chronological order, or that maybe they should cry just a little, but not too much because you don't want to seem crazy, right? And there's the shame that we rape victims are supposed to feel. So I've encountered lots of people who've told me, well, why would you ever want to talk about this? Aren't you embarrassed? Doesn't this come in? Make you feel weird? And honestly, it doesn't. I think that this is also sort of related to the deletion of teaching rape in law school in first-year curriculum. You see a lot of crim law professors who don't want to touch it because they think that it's a little too icky to talk about. So in the context of a criminal case, I look at how victims are shamed by police and their investigations. Cops are, no surprise, often under the sway of rape myths and shaming in the adjudicative process. And there's also shaming that happens, I think, amongst lawyers. And I think it also starts in law school, where we're kind of taught that there's some things that you don't talk about because they're not professional and they're not proper. And also amongst academics, I think. A lot of people argue this with regard to talking about mental illness and substance use, that you learn not to talk about it in law school because it's part of this sort of secret curriculum of how to make yourself respectable for the purposes of getting out there and practicing, right? I've also seen this, though, when I've been running around presenting this paper in many different venues, or not this paper, but also Ruined, in academia, where I've had a lot of people who have asked me in workshops or in the hallways, that's so brave, but aren't you embarrassed? Oh, Maybell, that's so tragic, but what took you so long? Hey, Maybell, are you sure that you remember this right? So I think law professors also cling to a lot of rape myths. And, I guess I was surprised initially, given our jobs and what we do, but I guess I shouldn't have been, and that was pretty naive. But, I could have written this paper again, and the last one too, without acknowledging and sharing details of my own experience, including the ways that it influenced how I approached my work as a prosecutor, and, how it was instrumental in me leaving that position, how it's affected the way I teach, how it's affected the way that I write. Some people might think that that's a little bit gimmicky or something. And I've had people be like, well, that's a little bit gimmicky. You keep treading the same road. Isn't this already what you've done with Ruined? So this is a piece that I looked at and I think about a lot when I write, actually. A series of photos by Robert Eugene Maitard that was shown at the Ogden Museum in downtown New Orleans about a year ago or a year and a half ago. And he was a photographer from Kentucky. And what he would do is he'd take a medium format or large format, in some instances, camera, and go take a photo out in like the woods or of a scene and take a photo of it and then move over and then take another photo of it and then move over and take another photo of it and interlay them on each other. So what you have here is one of those images. What you have here is another example. And to a large extent, this is sort of what it feels like to be in my position writing about this, having prosecuted these cases, having defended them, having lived through the experience. It could be a little bit disorienting, but when you put them together, I think that you can get a complex and sort of more interesting and sort of three-dimensional understanding of what's going on. I've also had some people say that, perhaps I shouldn't be using personal experience because it is lurid. Well, here's also a painting by Gentileschi that was critiqued as being lurid. This is Judith beheading Holofernes. Some people might think it's lurid. I think it's actually quite empowering to look at. But I've also had people ask me, after writing Ruined, if I would write about, my own experiences, again, just given the personal toll that's involved in doing this, which it is exhausting. Sometimes I present this and I will have to go and sleep afterward because it's a lot, right? And I could tell they asked this with sort of this bit of an edge of suggestion that maybe I shouldn't, right? Like maybe it's not good for you, or maybe that's not the smartest call or something like that. And I've been especially inspired now with this paper to continue to do this by Latin American testimonial literature, actually, in which testimonial centers on the participant who narrates her experiences to reveal exploitative and oppressive conditions while validating her own experiential knowledge. So I think narrative is really important in legal scholarship because it can provide a jolt. It can really kind of shock us out of our sort of complacency. And in this respect, I've been very much inspired by the work of artists like Ana Mendieta, Cuban-American artist. So while she was attending the University of Iowa in 1972, she learned about the rape and murder of fellow student Sarah Ann Ottens, who was studying nursing. So news of what happened spread quickly on campus. or is also written about in the local newspaper. And in reaction to this news and to the way Ottens's rape and murder were discussed on campus, and to the way that everyone on campus seemed to want to collectively just move on and be like, I don't want to talk about this, Mendieta performed the work now known as Rape Scene on campus. So this is Rape Scene. Sorry. So she invited her fellow students to her apartment where, through a door left purposefully ajar, they found that she'd recreated the scene as reported in the press. So while the original artwork was the performance, again, of this crime scene, it was a piece of performance art. As you can see in the photograph, she is stripped from the waist down and bent over a table. She's got blood smeared on her. The scene is dramatically lit. It highlights her legs, the side of her body and table, and it casts strong shadows on the wall behind her. Her head and her arms are tied to the table, which is not visible in the darkness, and there's broken crockery and bloody clothes that disappear into the shadows on the floor to her right, just to give you a bit more detail as to what's going on. And narrative, I think, can be a powerful tool to avert injustice and to prevent atrocity, which rape is atrocity. And the story that I know best is my own, right? And I can access it freely without having to worry about whether I'm harming someone else by interviewing them or pushing at their boundaries too much inadvertently or emotionally exhausting them beyond their capacities by making them speak about some of the most harrowing moments of their lives. So my story exists in my scholarship, merely as an example because I know other people are out there living similar experiences. So when she was asked why she painted herself so frequently, Frida Kahlo answered, "I paint myself because I'm so often alone and because I am the subject I know best." And I am the subject I know best. And because of that, I'm going to keep writing about what I know, as long as it has something useful to offer to legal scholarship, to the legal academy, and to others who might feel like they have something to learn from it. And some of you might be wondering, well, isn't there like something happy to this? Like, can you tell me something like positive or like optimistic? So, again, sometimes I feel very alone in this experience, but writing about this has been a really interesting sort of experience, having people reach out to me. I've had judges reach out to me, like, how can I do this better? I've had other victims reach out to me who are like, I didn't know that someone else felt this way, thank you. And sort of a bit of self-centeredness, I decided to go and look at my Google Scholar profile to see who was citing some of the stuff I'd written recently. And people don't reach out to you, but it's really touching to me to see a number of people who are writing about their own experiences saying, well, I'm doing this because Mabel Romero gave me permission to do it. And that's incredible to me. And it makes me really, really glad, because I think that a lot of our experiences should be brought more into our writing and should be put out there. I think that legal scholarship can be so much more than what we think it is now. It can do a lot more, and it can be a lot more. And I think we should all think about how we can accomplish that. But also, someone asked me, like, okay, you keep doing this. It seems like sometimes a sort of painful experience. Like, someone asked me this question when I was presenting some of this work in London at the Applied Legal Storytelling Conference. And, I left that conference and, was getting driven back to my hotel and had the driver stop because I needed to take a picture of this. This is at a fire station in London, and it says, "Love is the running towards." And, I think a lot of us think about why we write the things that we do. Like, okay, we might find it interesting. I think sometimes I've seen people like try to get really convoluted, like, well, it's because I want to make a difference and because I want to help people and and that's wonderful. I don't think that there's anything wrong with admitting that we're doing the things that we do a lot of time because we love it and we love the people that we want to serve, right? I realize I'm doing this because I love other people who've gone through this. My heart goes out to them. I empathize with them. I want to do what I can to make their lives better, to make it possible to talk about one's experience without being ashamed, to make it such that law professors might feel more comfortable broaching these issues, to make it such that the law doesn't devalue us the way that it does. And that's all because of love. And I think that that's okay. So I'm going to leave it there in case anyone's got questions, feedback, comments. I would very much appreciate it. I've got all summer to start revising this and thinking about it a bit more. So thanks, everyone. Yeah.
Well, not so much to revising this, but I mean, if you're continuing on with this project, it sounds like you are. I mean, it's just, I don't want to tell you what you.
Oh, no, no, no.
But I've heard you present before, and what's interesting to me is this time was a little different. The first part, and I've heard you present, I've heard you say some of these stories before, and the anger and frustration is very clear.
Yes.
So I would say, but the love at the end is somewhat new, and I wonder, question, comment, direction, if those are directions.
Yeah.
For future ways of approaching.
I certainly think that they are, you know, and I think that there's a lot to be said with regard to how perhaps using autoethnography and other forms of narrative can increase our capacity to feel empathy for one another, which I think is certainly lacking in a lot of what we do and what we write, and, you know, the way that sometimes I think even the way we teach things. So I think that there are a lot of really interesting, not just doctrinal ways of going about this, because I certainly plan on following up on a lot of scholarship written in the early 2000s in the criminal law about shame and shaming, that I'm coming for those folks, guys. I'm going to get them. But also with regard to how we approach like our pedagogy and how we approach our scholarship, I think that scholarship can also be like literature and art, and it can reach out and be expansive, right? So, you know, I think that that is something that's kind of new. And I think that I'm so affected by imagery, right? So I saw this and it kind of finally came together. That I certainly do think that that is a new place to take that. I appreciate you also noting the anger. I had someone write to me saying that this paper was like incandescently angry, you know, and it's like, yeah, it is. I think I've got good reason to be. Sorry, that's not going anywhere. But I think it is tempered with this now. So I appreciate you pointing that out. Thank you. Yes.
So I'm a huge, as you know, a huge fan of this project and all of it, and so I feel a little bad because it makes me realize that my work is whatever the opposite of expansive is.
That's okay.
Yeah, I'm not coming to be self-critical, but and also I feel like my question, there's some deja vu, so I may have asked you exactly the same question before last year. But I'm really struck by the kind of dilemma of thinking about how generalizable this is. I mean, it's obviously, you know, a very personal project, and in a very particular context of sexual violence. But it resonates with a lot of issues, for example, in bankruptcy about stigma and shame.
Sure.
And which is a kind of a big problem in every jurisdiction about how it's to get people to take advantage of the potential available to them, and people don't. But I don't, you know, it's not clear to me that I'm just curious to know, like, your thoughts on, you know, how you view the project in terms of its generalizability outside of a particular context. I mean, I could see ways in which that would be friendly, and kind of along the lines of what you have, but I could also see that it in some ways is missing the point for some aspects of the point. Just curious any thoughts.
I mean, I think, I don't know that you asked me that question last year, actually. I oddly remember things like each one of my presentations, oddly, and I take a lot of notes. But I've had other people sort of ask me something similar as to, like, you know, is this sort of the way that you'd approach shame in things like bankruptcy or public health or something like that? And I'm honestly coming more and more to the view that I think just trying to operationalize shame, like, it always backfires, right? And I think that you see that, like you said, in bankruptcy, because people don't want to avail themselves of the tools that they could use to help them. I think that that's even true in public health, where I have had a number of people be like, well, you know, perhaps it could be good because it motivates people to mask up or to get their shots. And I think that that is definitely ended up not being what's happened, right? People have ended up feeling stigmatized and just like not wanting to go see their doctors and not wanting to go to like whatever medical center it is that they should be going to and everything. I think that at one point, Gordon Smith at BYU was like, well, what about like corporate shaming, and I honestly don't know enough to be able to speak to that. But I think when we're talking about shaming individuals, I don't think it ever works. I don't think it's a good methodology, frankly. So I think that there is a lot that could potentially be generalizable, looking at this and being like, okay, is shaming necessarily the way to get people to do things in other contexts? I'm not actually sure that it works in sentencing, like criminal defendants, frankly. I don't think that it's helpful. And certainly that's going to be what I'm looking at next paper, especially, given other work that has touted it from like the early 2000s that everyone's kind of seemed to take for granted, like, yeah, that's a good idea. I don't think it is. So I think that this could be taken lots of places. I also think that it could be taken a lot of places when we're talking about just research methodology and the way that you approach papers, because I've seen people writing, again, stuff and talking about their own experiences with regard to Title IX litigation, or they're, writing things about like food insecurity and all manner of things. And they're like, well, it's because I saw you do this. So I think that that's incredibly generalizable, and like you could take that lots of directions. Thanks. I'm not sure who was first, so Evelyn. No.
But just knowing your work, and I've been thinking a lot about this idea of having not to take oneself out of the law. And so just like pulling back a little bit, I'm curious if you see yourself as kind of like a broader trend towards law and motion.
Yeah.
Because like I think about Barbara Welke at Minnesota is working on a book about, she writes about women in tort law, and I think her daughter died very recently, like a few years ago. So she's writing a book about her experience as a scholar and as a mother putting together. And then I heard a talk by Risa Law at UVA about like in the aftermath of the Charleston shooting here.
Yeah.
Where she gave a talk saying like it is impossible to write about this objectively, like especially for people who were there on the ground trying to figure out is the law safe. And she was like, I can't talk about this purely as a lawyer. I have to put my emotion in it.
Yeah.
And so I had not heard that before talking to them. And then like, it seems like your work is part of this like paradigm shift. So I'm curious about how you see yourself positioned in this new scholarship.
So, it's interesting because I'm trying to figure that out myself, right? And I think that's something that I really try to do with this work is also sort of explode the notion that there is neutral legal scholarship. Every bit of legal scholarship has a lens, right? Some lenses are used a lot more than others and a lot more commonly and have become a lot more accepted. So we assume that they're neutral when I don't think they are. So I think it's nice that like I'm able to talk about that, and that other scholars are starting to feel a lot more comfortable being able to do that. I have a number of projects that I'm following up on, even apart from the more doctrinal one, looking at shaming and criminal law sentencing and everything with regard to art. Again, art really touches on emotion for me, right? So something I'm working on right now is trying to put together a book proposal to submit to the Warhol Foundation with regard to, I'm hoping, the intersection of looking at contemporary art and thinking about rape law, right? So that's something that I'm thinking of doing and kind of working on frantically before the deadline, which is May 15th, right? It's like, I've also wanted to delve a bit more deeply into the law and emotion literature out there. I've been talking with Susan Bandes a lot about this, who writes about law and emotion in the criminal law. But I'm really excited to see this greater awareness and this, how would I put it? It's a lot more acceptable to be like, yeah, I can't take myself out of this and too bad. This is what you're going to get. And I think that that's like a lot more honest, and it gives us an ability to analyze work on a bit more of an equal footing that I think is really important. I hope to keep contributing to that in the future. So, thank you. It's good to like note that trend. I appreciate it. David.
Thanks for doing this today. Appreciate it. So I have more observations and questions, I guess. The first is juxtaposing your presentation, I guess, what just happened in New York yesterday with reversing Harvey Weinstein's convictions.
Yeah.
Which creates at least the context.
So the number of people are surprised. Yeah, that happened. Yeah.
But it creates the context in terms of how the legal system reacts to, ignores, and then corrects systemic abuse. And then the second issue is on the issue of quantification. So forensic psychologists, and I don't know how to do this, but they've actually quantified pain. And they've written books about this. I was finding, I don't know, painful and using this stuff. But they have this list of the 10 most painful things, and they quantify and say, well, see, this area of pain, this falls below the 2 level. This type of pain falls above the 10. The most painful thing that they identify is a parent who loses a child, to a young child. They claim that it creates more pain and human suffering than anything else.
Mm.
I'm amazed at that because I can think of at least 50 things that I think would be more painful. But my own perspective is that there may be something worth giving thought to that would incorporate forensic science and attempting to quantify the impact of shame. And this is completely different from your first article. But the issue for me is it opens up avenues for application both in tort doctrine for purposes of determining what an appropriate damage award should be. Because if we accept the notion that mental anguish is a compensable issue, that's not quite the same as shame.
Mm-hmm.
It's a uniquely distinctive human reaction. And the second thing would be criminal law sentencing as well. The consequence of causing damage to a person's property or injury to an individual, again, this is a much more unique thing. And I think that it probably is not going to have broad-based application in all aspects of criminal sentencing. It certainly won't have an application in all aspects of tort reform, but it clearly deserves to be considered, at least in 2 areas, because these are remedies. And these are legal remedies that are not written into our legal system, because if the majority of state legislatures are also controlled by males, then the notion that this is going to be a function of a legal system that they're going to be sensitive to has about as much of an opportunity as Harvey Weinstein ever being convicted, sentenced, and locked up in jail, because as soon as it gets back into a court system, that the insensitivity of the court system will prevail.
I mean, that's, you talk about the insensitivity of the court system, and it certainly is. That's actually something that I wrestle with a lot, though, when, we think about cases like, say, Harvey Weinstein's. Well, there's no one coming after me, right? Oh, sorry. I'll be done. I'll talk with David afterward. Oh, sorry. I mean, and this is something that I wrestle with a lot, because it's like, I also care about, defendants' rights as well. So I remember, following the Harvey Weinstein trial and being really antsy about them using all this like 404B evidence, where I'm like, this is going to blow up in their face and maybe they shouldn't be doing this. And behold, it did, right? So it's like, when I read the news, I wasn't all that surprised, because it's like, prior bad acts, it's always like a little bit, that makes me antsy to always rely on that. So, I've had people ask me like, well, what do you do about, the criminal defendant and all this? And that's something that I've been struggling with, right? I understand why you shouldn't be allowed to use like prior bad act evidence and everything. I'm not necessarily sure that's an example of insensitivity so much as like, it makes sense to me, like, well, that doesn't necessarily prove that this happened either, and that's important to think about. And so, yeah, I appreciate you like, addressing a number of issues that I've been wrestling with. Like, I don't know how to deal with that. I honestly am like, I don't even know how to go about starting to quantify some of this. Like, I do not have those tools. I've got to find someone on campus who does, because it's like, that's like far outside my own experience, but something to think about. So I appreciate it. Thank you. Anyway, thanks everyone for listening.
All right. So I have to present a paper in June at the Law and Society Conference that I have not touched for literally 10 years. Okay, so this was my first, right. So this was my first seminar paper in grad school, back when I thought I was going to do women's rights. And I got invited to present just super randomly by this wonderful panel of scholars who are talking about just kind of liberalism and women's rights, like over the course of the 19th, 20th century. And I was like, I actually have something. And this is a paper that is like super close. It's a case that is so close to my heart that the reason I have been sitting on it for so long is I don't know how to do it justice. And I just love like a perspective on like, how do I treat this case with the kind of just like honor and compassion that it deserves. And so Maybelle in particular, I think maybe like your help with this would be great. So the case is called Pratt v. Davis. It's the seminal informed consent case. It influences the entire doctrine of informed consent in the medical context. It is cited by what is said to be the seminal case, which came out of the New York Supreme Court. But no one knows about it because it's an Illinois Court of Appeals decision. So it's like real, and it's from 1910, I want to say. But it's this absolutely beautiful opinion about women's rights to bodily integrity and women's rights to personhood and citizenship. And so I wanted to kind of unearth the background of this case because it seems really striking that in this moment where women still don't have the right to vote, where there's still all these vestiges of coverture happening, you have this beautiful opinion that's about women's rights as independent, kind of rights-bearing, bodily owning persons. And so the background of this case is there's a woman named Josephine Davis who's in her 40s. She has several children. She has epilepsy, and she's like middle class. Her husband is a traveling salesman. She lives in Illinois, and she has tried to find a cure for her epilepsy for years and years and years, and nothing has worked. And so finally, her brother-in-law hears about this homeopathic doctor, and he's like, well, let's give this doctor a shot. The doctor is Dr. Edwin Pratt. So he did a lot of research on Edwin Pratt, and he is terrifying. He belonged to this kind of subset of the medical profession that believed that, this was actually not that unusual, believed that all mental ailments that women had were connected to ailments of their reproductive functions. And so this group of practitioners believed that if you remove the uterus or the ovaries of the women, then their mental defects would be cured. And actually they're so blatant about this. They have these reports of their conferences where they say every young doctor should have a jar of ovaries on his desk, preserved ovaries, to show his surgical skill. And this is the medical profession that Dr. Pratt is coming out of. And it's horrifying. Like he performs operations on girls as young as 8. And a number of his patients commit suicide. Actually, it turned out when I was researching him, kind of kind of unexpectedly, I guess, when you think about it from this perspective. But so I was trying to figure out, all right, what's going on with Josephine such that she ends up, and what's unusual about Josephine is she sues him. She ends up suing Dr. Pratt because her brother-in-law takes her to the clinic. Dr. Pratt says, yes, I can help you with your epilepsy. Come back at this particular time. So she does. She has an epileptic fit in the waiting room, perhaps because she's nervous or who knows, but he ends up chloroforming her and he performs a hysterectomy without her consent. And she wakes up in the operating room and she says, what have you done? And he says, I did it for your own good. He says, be a good girl and follow my instructions. And so, of course, she goes through menopause and she has this, this is what I pieced together, is she starts to act erratically. She's angry. She convinces her sister's husband, who is a lawyer, to bring a case against her for informed consent. And she introduces this novel theory, which is that I have a right to my body and you did not get my permission to do this. And therefore, you have violated my right to bodily integrity. And this is a completely novel legal theory. And so Dr. Pratt comes in and he uses this theory of, what I call status, where he says, first of all, am I walking?
No, you keep talking. Sorry.
Okay, so what he says is, well, first of all, your husband consented. And she says, that was not my husband that brought me in. That was my brother-in-law. And she was like, my husband was out of town because he's a traveling salesman. So then he's like, okay, well, as your doctor, I have paternal authority over your body. I'm a man. I know women's bodies. You're epileptic. You're just like mentally incompetent and you don't know. And what happens is that she ends up getting, first at the district court level, she has a judge whose sister is epileptic. And so he recognizes this cause of action. And he holds for Josephine. And then, the doctor appeals and they get to the Illinois Court of Appeals, where the judge is, whose name I'm forgetting right now, but he was an abolitionist. He was one of the founders of the NAACP in Chicago. He also supported women's rights. There's a fabulous story about him where he's from the East Coast originally. He's at law school, and there was he's at law school, and there was one African-American student at the law school. And this is during, Jim Crow. So the other law students, the white male law students, decided they didn't want this student there, and they were going to have a vote in student council to kick out the black law student. And so what this judge did was he paid the janitor to turn off the lights in the middle of the vote in the room, and it threw the room into, he wrote this autobiography, which is like brilliant. It threw the room into chaos, and the vote never happened. And so he was he believed very strongly in the rights of personhood. He also was he was a mentor to the first female medical, whose name I'm forgetting, the first medical student in the US who went. Yes. And so their families were friends. They would go on vacation together, but he was her mentor. And so he was like incredible. He wrote about how he, heard Elizabeth Cady Stanton talk, and it was revolutionary. And so he had this very strong conception of personhood. And so this is all the background that I did on him. And so Josephine's case comes to him, and it's really tragic what happened. So Josephine has kind of spiraled down. And her husband ends up committing her to an insane asylum, which is one of the most, so this is insane asylum in Kankakee, Illinois, which I actually have, if I had pictures, I have a picture of the graveyard, like I drove there, and like it's all fenced off and overgrown, but it was one of the most horrific places to be incarcerated at this time. And patients, if you weren't crazy when you went in, you were crazy soon after. And so, so the reason he was able to convict her, because husbands at this time could bring, could kind of unilaterally convict their wives in front of a commission of all male doctors who would assess whether or not she was insane. And the evidence that she was insane was she told her teenage daughter she wanted to kill her, which like kind of what mom doesn't tell their 13-year-old at some point, like what mom doesn't feel that, right? She knocked all the dishes off the table. Something about a fireplace, like she threw something into the fireplace, and this is while her case is going on. And eventually she tried to jump in front of a moving train, and she was just clearly suffering so much emotional trauma and stress, and was not getting the support from her family that she needed, except from her brother-in-law, who had agreed to bring this lawsuit. And so all of this evidence, the husband goes before this commission, they agree that she's insane, and not to mention she's also epileptic, and they confine her in the insane asylum, where she dies. She dies before her case is heard by the appellate court. But so the judge gives these facts, and then he says the right to bodily, I wish I had the quote, but he says the right to bodily integrity is the paramount right of all persons. And any person has the right to contract for medical care. He said this is not a relationship of patriarchal status. This is the relationship of, this is a market transaction. And any actors in a market transaction have the right to consent to the transaction. And he said, Dr. Pratt clearly did not get Josephine's consent before this, and so he is lying. So it's this beautiful opinion that's all about, what's interesting is that it's not written saying her. It's in this generalized terms of like all people have a right to bodily integrity. And then he even uses the male pronoun when he talks about it a little more. So it's like this epileptic married woman, her case sets this abstract standard for informed consent and bodily integrity, which gets picked up by other courts and becomes like the basic tenet of what informed consent in a medical context is throughout the 20th century. But nobody knows about Pratt v. Davis, because it was cited once by this New York court, and then after that, everybody cites the New York Supreme Court case. So what I think is most interesting about this case is this is happening in the Lochner era, right, in which the freedom to contract is paramount, individual, free-willing. But then at the same time as Lochner, you have the case of Mueller v. Oregon, which is the case about the women launderers. And the court says they don't have freedom of contract because the state has an interest in their reproductive capacity to produce healthy citizens for the nation. So you have Lochner and you have Mueller. As Lochner, where the free-willing men get to decide their contracts, even if they're actually being oppressed and labor employer imbalances in the spirit. We're going to ignore that. free-willing men, but women are not free-willing to contract. They, because the state has an interest in their reproductive capacity to create strong, healthy citizens, right? So you would think that like the Mueller logic would kind of take over in this case, but the judge instead uses this kind of Lochner-based contract free-willing idea to support women's rights, right? Even though Dr. Pratt raises this, he says the relationship between the patient and the doctor is not like going into the market to buy shoes. He very explicitly says this is not a contract, this is a status-based relationship between women at the bottom, doctors as this paternal figure on top. This is a hierarchy of power, right? Especially when the woman is also mentally disabled, is what he's saying. So, but the court says, no, this is pure contract, pure free-willing individualism across the board. So that's the case. That is what happens. I have been trying to figure out what to do with this for years in a way that honors the sacrifices that Josephine made. And so that's it. I would just love your thoughts about like, what do I do with this? And okay, Maybelle, go ahead, please.
It was like such like empathy and compassion that I thought that even being able to write about it the way you're speaking about it, just to introduce everyone to these facts is really helpful. I think it would be really interesting to contextualize this sort of line of pieces and how I'd be curious to like see what happens, starting from this amazing, beautiful Illinois case. And I guess what I'm wondering is how do we end up from there and then have the New York, court pick it up and run with it? How do we end up with like this system where still even in recent times have women who are undergoing pelvic and other sort of gynecological exams without consent, right? You just had, I think the FDA passing their own regulations saying, hey, finally you've got to start getting, hospitals have to start getting written consent for pelvic and like other sorts of gynecological exams. So it's like, okay, how do we go from this, and then maybe like other courts picking it up to like this BS that we were dealing with even recently. Like I think that'd be really interesting to contextualize that in that landscape. I think it'd also be really interesting to contextualize that in the landscape of, other sorts of forced sterilization that happened in like the 1900s. Like, for example, I think of in Los Angeles and other parts of California where Latinos were forced to be sterilized, like left and right if they wanted to get, benefits, or, maybe they just would have, some other operation happening and they wake up and they have no uterus, right? There was definitely this very state-sponsored sort of regime of, well, we want to control like Latino like populations. We don't want as many of those people like having children, right? So I think like connecting this with these other I think really sort of serious, really jarring examples of like violating women's bodily autonomy in this medicalized setting would be really interesting to be like looking at like okay, we had someone who was actually doing the right thing. Like people had a concept of what the right thing was back then, but how did we end up in this morass where we're still trying to like disentangle ourselves from this way of approaching this medicalized sort of context, right? I think that'd be really fascinating.
This is great. Yeah. So I think one of the big things that happens is the eugenics movement really takes off like right after this case. And then you have the Buck v. Bell case, right, where the penitentiary is like, guess what? We get to like, it's not a violation of due process to remove the uterus of an incarcerated woman. You have Justice Holmes saying three generations of imbeciles are enough because the woman, was raped and had a child out of wedlock. Therefore, she must be mentally incompetent. So it's okay to take out her uterus, right? That's the Buck v. Bell case. And so it becomes like constitutionalized that it's okay for state actors to do things like this. And Buck v. Bell actually was cited in Dobbs as still good law, by the way, right? So I tell my students that they're like, oh, but yeah, so I wonder if it's like the eugenics movement, and then it's, you've got these really intense like population control, racial, like kind of gendered racial concerns that obviously still carry out to this day, right? So what I'm curious about then, is this like a combination success and lost cause story? Like success insofar as we have a formal doctrine of informed consent, and kind of lost cause as we had a potential to recognize women's bodily integrity as part of that, but clearly that part has not been fulfilled in practice in spite of this law on the book. So is it like a kind of dual, some success and some not, like women's stereotypes about women won out at the end of the day?
I mean, I think that'd be a really interesting way of approaching it. I also really love narratives where it's like, I think a lot of times people are like, well, people back then were ignorant and just like everyone thought this about women and everything. And I think it's like really interesting to point out, no, there were people who actually saw things the way that they should have been. You know, this was recognized by some people and people didn't listen to them. Other people didn't listen to them who were in more power, I guess. You know, and I think that you've seen really, I feel like I've seen other interesting like examples of papers where it's like, no, look at this back in like the 1700s where there were still abolitionists like back then, and we don't assume that they existed, but they did exist, right? So I think like actually highlighting that, you know, maybe we have this constant, there's like a, how do I put it? I'm not like a legal philosopher, right? But maybe they're like actual constant like things that are just and good and right that exist out there. And they have always existed. And maybe if people would like recognize them like flashes of like, yeah, I got, you know, recognizing that. And then what's the story behind like ignoring that? You know, so I like this sort of dual sort of thread way of approaching it that you're describing. I think that'd be really like fascinating read.
Okay, great. Stacey, what do you think?
I think this may not be as factually similar as you would need, but I can't help thinking about the USC class action involving a college gynecologist who's examining undergraduates and committing reviews. And everyone in the clinic kind of knows it's going on and they don't report it. Or that whatever they're doing isn't really being reported to the right, to people who can do something about it. And this went on for years and years in the modern era.
Yeah.
And only relatively recently does it get, you know, does it result in litigation that then, you know, creates this massive conversation at USC about their, you know, their structural inability to deal with issues like this. And they created like this crisis at USC at the highest levels. It's like, how did this go on for so long? So I
Yeah,
don't know if there's anything there for you to work.
I mean, that
with,
could be
but-
something in the introduction to flag like, hey, this is still going on. This is, you know,
I think he was literally like fired like only 5 years ago.
yeah, I remember this happening. Yeah. Carla.
That also happened. As I was thinking about the case, I had two thoughts on the story. It's for access to things, like access to a brother who was a portal.
Yeah.
So like how much of her status, her social status was leaned into by the judge to say like she has more knowledge, we should be believing her. And the fact that the brother-in-law did believe her, like what was it about the brother-in-law? That like my curiosity is more from the legal standpoint.
Yeah,
like,
yeah.
I mean like the legal professional standpoint of like the brother-in-law, one would expect when we back to Neil's point that like there were people who had that like justice idea. One would expect the brother-in-law to side with the husband and to be like, nope, she's crazy, or with the doctor because it's another professional. And yet he filed the case and then continued on to beat that drum. And so like the sign of the times that we expect, like we put these broad like assumptions about what people in society thought about women, about their consent. And so this drumbeat is what I thought when Maybell spoke about, like, there were people being thought of like the morality and the justice. And so it's like, it isn't a sign of the times because people were able to address the discrimination and the assumptions even in that time. So beating back against that would be fascinating.
So figuring out who the brother-in-law is, right? Yeah, but we gotta be done. I know.
And we do have like,
Yeah.
I have to keep the trains running. Sorry.
Yeah, well, thank you. Super helpful and would love to hear more thoughts.
So off we go. Everybody knows the reference from tiny acorns, mighty oaks do grow. This presentation is about a mighty movement that arose around trees. At this point, I can hear my son, Ben, saying, oh, that's a real first world problem, Dad. but maybe not quite so cut and dried, Ben. Here's a model ordinance report prepared by the Mid-American Resource Council in Kansas City. Spends the first 10 pages talking about why trees are important. And here are a few of the headers: climate adaptation and mitigation, health benefits, economic benefits, transportation benefits. Here's a quote: trees make places more valuable, and this in turn generates more property taxes, causes more reinvestment, creates a more stable neighborhood. And one more: all trees produce benefits, but older and larger trees produce them at higher levels. So there's a message here, but I don't want the message to get in the way of a good story. Let me tell you how this project came to happen. It all began on a morning when Jane and I were taking our walk in the neighborhood on Carrollton. 2 blocks from our house, we see this truncated tree. The day before, it was 3 sturdy branches reaching for the sky. The day after, it looked like somebody sliced the thumb off right at its base. And I thought, did anybody in the neighborhood know about this? Did it happen with no warning? Well, the obvious answer is advance notice, right? This is something that a neighborhood organization should take care of, get Parks and Parkways to tell you before they come out and just chop a branch off. Simple, straightforward solution. I sent the suggestion to our local neighborhood group. Nobody did anything about it. I didn't give it too much of a thought further until it became a project when this mighty oak came down across the street from our house, fell on Carrollton Avenue, blocked traffic, riverbound, stopped the streetcar in both directions, fell on a lady who was turning the corner onto Spruce Street, onto her car. Happily, she was not injured. Kind of a miracle because it crunched the car pretty well. So Jane and I watched this Entergy tree debris removal project with a certain air of disinterestedness from our front porch until something happened. Tip O'Neill, former Speaker of the U.S. House, said, notably, all politics is local. I think he was right. You see the person, let's get rid of that. Why is that thing hanging around, I wonder? Any idea? We'll back it up. Good, okay, great. That'll do. That'll do. This person standing on the sidewalk is standing right in front of our house. So this was our near neighborhood, but it didn't fall on our side of the street. And as I said, we were watching it rather disinterestedly until the bucket lift went up and a guy in a buzzsaw started eyeing the trees on our side of the street. So I went out to talk to the Entergy supervisor who was on our front sidewalk. We had a very brief and very unsatisfactory conversation. And you know what happens when a guy with a chainsaw goes up in a bucket lift? No, you don't know, and neither do I. The guy's completely beyond anyone's control, 40 feet up in the air. And once they get started chopping limbs, who knows, it's like a runaway freight train. So this was the origins of advance notice as a desirable goal. The truncated tree happened in the spring of the year because it was still cool enough to walk outdoors. This happened in September of last year. And here's what I said in the first email that went out to people trying to organize them. World's worst system, buzz saws blaring, 2 people who've never met screaming at each other, and a guy in a bucket lift with unconstrained discretion. Insane? I'll stick with that. So advance notice was the only way to prevent this insanity from happening over and over again, which is, by the way, the informal definition of insanity, doing the same thing over and over again and hoping for a different result. So here's where tiny acorns enter the frame. The asterisks are my metaphor for the recipients of my various emails. And as you can see, this was a very modest recipient crowd, 6 people. Note also the media link. I found in this process that press coverage is a wonderful way to focus the attention of public officials, and we relied on it to good effect throughout. So my next email was 2 months later. First one was in mid-September. This one is in November the 12th. It's a Sunday evening, 9:15. And it's the night before we have gotten word that a big oak tree on Willow Street is going to be taken down by Parks and Parkways on the following morning. So this goes out sounding the alarm. Parks and Parkways told the adjacent property owner about its plans, but not the neighborhood or the neighborhood association. And they told the adjacent property owner on Friday that they would be out early on Monday morning to take the tree down. Here's what the tree looked like. Pretty good sized oak tree. And that's the property owner's house, you see, just adjacent to it. The social media side panel called upon PPW to pause the chainsaws. And within less than 12 hours, my email went out at 9:15 at night. By 7 the following morning, we had a dozen people on the street there to express their views about taking this tree down. And happily, we won that battle. You know, you win a little victory, and all of a sudden the enthusiasm goes up. You can see the acorns have grown from last report 16 to now 22 of them. And as it said at the bottom, I'd added a lot of new names to the list. The article that appeared in the Sunday paper by Stephanie Riegel generated still more interest. At this point, there are 30 recipients grown from the initial 6. And this is where I leave the acorn metaphor behind and talk about the factors that went into this advocacy strategy that we deployed. We now at this point had a name, Tree Canopy NOLA, or TC NOLA for short, and we had multiple organizations supporting us. You know, the time was well spent between September, when the big oak came down on Carrollton, and November, when we succeeded in reversing Parks and Parkways' decision on Willow Street. And in that time, we had recruited 8 neighborhood associations and 3 citywide organizations to support our cause. They came from diverse areas of the city, Carrollton and the Maple area, Uptown, Mid-City along Bank Street, Gentilly Terrace, spanning 3 councilmanic districts represented by Giarrusso, Harris, and Green. So we celebrated the success on 7918 Willow. It was a satisfying win, but we didn't think that it should be related to a last-minute curbside intervention. Our conclusion was that we needed to establish an ongoing collaborative relationship between neighborhoods and parks and parkways. Easier said than done, but that was our goal. And we set out in meetings with Parks and Parkways during November and December the following 3 objectives: collaborative tree care in 3 pilot areas, a public-private partnership between Parks and Parkways and Tree Canopy NOLA and other tree-related organizations. Secondly, a city code update of inadequate tree ordinances. I think everybody agreed that the city code tree provisions were just completely inadequate. The council were on board with it. The Parks and Parkways folks were. So that was a high priority item. And thirdly, we thought we needed a website to provide an umbrella coordinating capability. So how are we going to accomplish even the first of these objectives: collaborative tree care and essentially advance notice from Parks and Parkways? Parks and Parkways did not want to give advance notice to neighborhood organizations that they were about to go chopping on a tree. And if you were the director of Parks and Parkways, how would you feel about doing that? Maybe not wildly enthusiastic, so I can relate. Well, how are we going to manage to move parks and parkways? Here was the conclusion we came to. We will not overpower parks and parkways. And I used to illustrate why the contest between wind and sun in Aesop's fables. They were in a contest to see who could get the ancient Greek to remove his cloak first. And the more the wind blew, the more he huddled it around himself. And when the sun came out, soon enough, he took it off. Parks and parkways will not surrender its cloak of autonomy in deciding about trees for simple reasons powerfully rooted in civil liability. If public trees cause damage, the city will get sued, and not too much longer after these events, it happened in Jackson Square, where a gigantic tree came down on some poor 17-year-old kid who suffered, by all accounts, enduring neurological damage as a consequence. Morris Bart filed a lawsuit within less than a month thereafter. So parks and parkways will forever want last word discretion over trees on public property, because they know that the city will forever be sued if those trees cause damage. T.C. Nola's commitment to collaboration with parks and parkways was not simply a factor of kumbaya. It was born in a practical strategy. If you want to get parks and parkways to give you some role in the fate of trees, you've got to find a way to incentivize them to collaborate with neighborhoods. So let's take the pilot project approach. Here we had three areas: Carrollton and Maple area uptown, Gentilly Terrace toward the east, and Mid-City and Bank Street. We wanted Parks and Parkways to initiate these pilot projects and collaborate with us. And we had a good model, which is the St. Charles Avenue Association. I didn't know until I got into this, but the St. Charles Avenue Association has been doing for 50 years a collaborative venture with Parks and Parkways along the length of St. Charles Avenue. They care for the trees from Riverbend to Harmony Circle, or as you see, I like to call it the Lee Stub. A major problem with this model is that it's expensive. St. Charles Avenue over the length is about 4.5 miles. If you add up all the mileage of the three pilot areas, it comes to about 5.5 miles. St. Charles Avenue Association spends about $35,000 a year in collaboration with Parks and Parkways. One hopes that Parks and Parkways matches that. If you play the numbers out, about 25% more would mean that T.C. Nola is going to need to have about $45,000 to go have a serious discussion with Parks and Parkways about collaborating on tree care. So the second objective, city code update. I should have mentioned what I didn't, this bottom bullet point. We've applied for foundation funds. We've gotten some favorable response from one of the foundations. We're waiting to hear from the other. So that aspect is underway. With regard to the city code update, we sent an email at the very end of January to all 7 city council members. We said we wanted a comprehensive look at the inadequate tree ordinances in the city code, and we wanted to have all stakeholders represented at the table. In February, I had meetings with representatives of the District B and E council offices, and out of those discussions grew the agreement that T.C. Nola would provide a proposed ordinance by the end of March, before the end of March. And the council had this set for its May the 6th Quality of Life Committee meeting. It was going to be on the agenda. We delivered this 12-page discussion draft ordinance on March the 22nd, a bit ahead of schedule. And we had a stakeholders meeting scheduled for today in Leslie Harris's office. I actually prevailed on Adam and Ann to switch my presentation from 12:30 to 11:30 so I could make my way back down there at 1:30. Well, this was an accurate slide up until yesterday. Early morning, I get an email from Mike Karam, the director of Parks and Parkways, that the meeting is canceled. And There was no arguing that on the day before. The council offices had already sent out such notice. So what happens is the date of the quality of life committee meeting discussion about trees has been moved from April 25th to May the 29th. We'll go, but we want to be sure that we get a copy of the draft that Parks and Parkways has been working on since we delivered our draft to them now more than a month ago. This line is still active. We intend and believe it is feasible to enact city code updates before the end of 2024. So advance notice is served by this city code update. We larded up the discussion draft ordinance with multiple transparency requirements. If we can get online posting of permits and arborist reports and notices of violation, street construction plans and mitigation measures, we don't have to go on bended knee to PPW and ask them to give us advance notice. All of those plans should be online for public view. Third decade of the third millennium, it is time for public sector business to migrate onto online platforms, but don't tell Jeff Landry. The website serves an obvious purpose, which is to give a forum for citywide advocacy by all of these discrete neighborhood associations. And we hope to put it into play in the very near future. But we are still in a brass knuckles battle to protect the city's trees. And here's an example on St. Roch in the Gentilly Terrace area. This project has been going on since November. A neighborhood resident sounded the alarm about it. Parks and Parkways came out, they stopped the project. It was out of compliance in so many ways, but it started back up again and it's got a year to go. There is still a lot to be fought over. So it's a commentary on why we need the city code update. Parks and Parkways needs the tools to have real legitimate enforcement authority, and they don't have it right now. So what nurtured TC NOLA? Well, you get a good idea, which is advance notice, and champion it. Build a coalition, borrowing the credibility of neighborhood associations to promote a conversation. Catch a break. Getting that decision reversed on Willow Street was a big success. The media allow you to get the public interested and they command the attention of public officials. Propose pilot projects and secure the money to fund them. Story on the money isn't in yet, but it's headed in a favorable direction. Legislative drafting can be used to set the agenda and develop public policy. And you educate and engage the public via website resources, which we'll soon, we hope, be able to do. So, trees, what are we fighting for? This is a social equity issue. Heat islands disproportionately impact poorer neighborhoods. Tree canopies reduce temperatures by 15 or more degrees, and shady surfaces can be 20 or 30 degrees cooler. This is an environmental issue, and not surprisingly, a health issue. Trees reduce pollution, they absorb CO2. Green stormwater infrastructure can reduce greenhouse gases and other environmental or climate change objectives. GSI can also mitigate flooding on city streets, preventing damage to your car, preventing damage to the esteem that we feel for our city after we are constantly inflicted with this problem. Shade from trees extends asphalt's life by 50%, so you can cut back on street construction costs. And they, by the way, have their own environmentally damaging impact, as we saw in St. Roch. Workforce development. Tree ordinances create a demand for green jobs that fill in what's called the missing middle in employment. Pays more than a minimum wage, but without the necessity of a secondary degree. And they boost property and recreational values. And of course, they are beautiful. So, TC NOLA also builds social capital. We are an affinity group. We bring like-minded people together. In a society where many traditional institutions are eroding, TC NOLA is an antidote to alienation, cynicism, and powerlessness. TC NOLA, like other civic action organizations, contributes to the glue that binds communities together in a common enterprise. I like to think TC NOLA is a renewable resource. So, within my time constraints, any questions, any comments? Adam?
So I stuck around, I'm supposed to be recommending this here, because I'm really interested in this. And I should preface this by saying, I hope you and Jay know that I would follow you into battle, like without any explanation, like, and this sounds great. And I do think that more community engagement with PPW is really important. The city code update, especially, is great. I had this kind of weird experience with PPW in the neighborhood that I wonder if it might be a little bit of a counter narrative to at least some of what you were saying. So there was a neighbor who bought a house. There are 5 live oak trees along the, I think 5, and immediately applies to the city, PPW, to cut down 3 and replace them with other trees. I only know about this because one of the arborists at PPW is a friend, and he was telling me about this. I was mortified that the city was going to let his neighbor cut down these live oak trees, and my friend kind of gesticulated and said, "I know everyone loves these live oak trees, but like from an arborist point of view, these trees are crowding each other. Like these other trees are gonna like, with this mix of trees, it's actually gonna be better from a tree perspective." And it was quite clear to me that, and this is not the city, this is like the arborist at PPW. So I know this is not a statement about the government agency, but my sense was that there's like, if the neighborhood had known in advance that these trees were coming down, it would have made their life. I don't think it would have happened. I'm torn because I like live oak trees, but my friend, the arborist, felt very strongly that for all of these reasons, like from a overall tree perspective, this was the right answer. But if one is committed to live oak trees in particular, it's not. So the broader point is that it may not just be the liability, that at least in some circumstances, at least, the agency may think it knows the right answer, and that popular support will be driven by aesthetic rather than scientific perspective.
Right.
I don't mean to suggest that that's like the primary motivation behind the kinds of problems we've been observing, but and I don't raise it to suggest that any critique whatsoever, but it was an interesting, kind of perspective that was quite different than my own.
Well, there's a lot there to unpack. Before I start doing it, I'll say that one of our good friends said early on, you got to set up a bail fund for those of us who are going to go out and chain ourselves to a tree, but it hadn't gotten to that yet. So the arborists report. One of was it a DPW or Parks and Parkways arborist, somebody inside of the agency? Yeah. That, of course, troubles us in terms of the independence of the viewpoint. Parks and Parkways doesn't take down a tree unless they have 2 arborists' opinions, but they're both from within Parks and Parkways. One of my ambitions for Tree Canopy NOLA is to be able to hire an independent arborist opinion when that becomes pertinent. And one of my other ambitions is to take lay people out of the equation. I would like to have an arborist on our behalf talking to the arborist at Parks and Parkways. The other 2 items are public trees and private trees. If they're on public land, that should be easier to regulate. But the ambitious ordinance that we drafted also aims to regulate the management of trees on private property. It's no different from the dependency on the back of the property. We don't allow people to take that down to put in a swimming pool or a tennis court. And I don't think we should be any more lenient with regard to big, beautiful old trees. So thank you.
So we're gonna go ahead and get started. This one sec. So this paper is something that Lauren and I worked on as part of a symposium from the Washington University Journal of Law and Policy. It stemmed from an observation that there's a real gap in existing literature and about climate change adaptation and mitigation around renters and policies for renters, proposals that are renter specific. If you look at public guidance documents around climate change plans, renters really get short shrift. There's not a lot of programs explicitly targeted at them. So for instance, if you look at the Louisiana Climate Action Plan, renters only appear 3 times and kind of at the end of long lists of examples of people that need to be getting assistance. So what we attempted to do here was to kind of figure out, well, name specifically why this is a problem, why this results in a disproportionate impact, in particular on communities of color and low-income communities, and then run through what types of benefits actually are available for renters, because no one had really put them all together in one place that we could find, and then posit some high-level solutions for how this gap could be bridged a bit. So Lauren, I'll let you talk about your section first.
Sort of what you just said.
Oh, I'm sorry.
That's okay. That's okay. When you think about the impacts of climate change and sort of on large scale, there's your classic ocean level rise, loss of sea line, and there's also these sort of extreme weather events. And we're the media, and we're all sort of generally familiar with those. But there's also the concept of just like long-term irreparable change in climate conditions and weather conditions, heat spells, cold spells, and all sorts of things that are going to have impacts both in the short term and long term for all of us everywhere. And there are, this has been happening already. As I stand in New Orleans and say this has been happening already. Extreme weather events have been happening forever. And we generally have social approaches on how to respond to that. Climate change responses have been sort of falling into a lot of similar things to disaster responses, which is all sort of premised on, and there's an asset. We know what an asset is. An asset is this house. This house needs protection, repair, or compensation. And there's sort of a social idea that you deserve, the asset deserves compensation or repair or protection from society. But if you take the asset ownership out of that equation, what happens? It sort of falls apart because we don't have the built-in mechanisms already in our policies that just can give you, who does not own an asset, a livable, repaired asset. So we talk about in the paper sort of the history of how we got here, and it's a big historic section, much of which we rely heavily on the scholarship of Stacy, so direct questions of her. But there's sort of 2 major trends in history, right? There's a disproportionate ratio of wealthier white populations that own homes and poorer and minority populations that do not. That's very well known, very well established. On top of that, there are the legal and political systems that reward, value, and compensate and are concerned with property ownership that overlay and sit on top of the disproportionate ratio of ownership. And our gloss on the trends was sort of the climate change is a disruptive force that's going to affect everyone. But how is it going to affect the populations that aren't necessarily valued by the existing property law systems the most? And you think about, you might at a surface level think, well, it's ocean sea level rise, it's millionaires, beach houses getting washed away. Who cares? That's not really a problem for society writ large. But it's really not that. It is that in part, but most of it is going to be sort of these long-term heat waves, these long-term cold snaps, these unexpected weather conditions that apartment complexes aren't
weatherized against, long-term and regular and routine floods like we see here. So those are the sorts of things that we started getting concerned about. And most of the historical section, again, came from the sort of seminal basic works like Color of Law. But we also looked at Stacy's research and Professor Davida Finger's research from Loyola in post-Katrina New Orleans, and how the historic trends are sort of replicated every time there's a new disaster, and that public housing just gets diminished further and further, and that Section 8 and government-funded vouchers just get more and more geographically and racially segregated over time. And there's a million examples of that, but we happen to be standing in one now. This is where we are. We've got our sort of flashy billion-dollar climate disasters that come with increasing ferocity and rapidity. They don't just affect the coastline, as you can see, they're all across the nation. But what you can't really see in the big sort of short-term, flashier climate change disasters are also the long-term risks. There are a million of these really scary, horrible lists that insurance agencies, insurance company policy groups and lobbying groups put together, where they sort of very coldly and economically assess the insurance risks of cities and try to figure out these top 10 or top 20 like worst cities for climate change. And there's a bunch of different lists, and they all sort of congregate around Florida, but they have slightly different cities. I picked one that was fairly recent from an insurance adjusting group that came up with the worst 10 cities over the next decade that are going to be most adversely affected by the long-term impacts of climate change. And then, and those are what the stars are. Then I checked to see in the most recent US Census data, how the percentage of owner-occupied versus non-owner occupied housing. And you'll see the yellow stars are where there are a majority of owner-occupied housing. The majority of the population lives in owner-occupied housing, and the red stars are where the majority of the population lives in non-owner occupied housing. Now, there isn't good data at the US Census level for renting, so I'm sort of extrapolating that a lot of those folks are going to be renters. There are other less consistent data that does tend to reflect those numbers about renters in cities, so I feel fairly good about the numbers. But for instance, Miami, which is our southernmost star down there, it's always on the list, is one of the cities that's going to suffer the most from the impacts of climate change, and it's only 30% owner-occupied housing. So at least 70% is either renting or in some sort of non-owner occupied housing situation. Los Angeles, 36% owner occupied, which I get. I know lawyers in LA that are super rich and still renting because you can't buy houses there. So it makes sense, but it's not great in terms of there are no built-in social controls to help with that adjustment to climate change.
Okay, so after kind of situating this historically and looking at the kind of unique issues faced by renters and the gaps in the current policy landscape, we did an assessment of what benefits actually are available to renters, starting at the federal level, moving to states, and then looking at a sampling of some local policy initiatives that have been taken by some cities. So this is probably, familiar to most folks who live in New Orleans and who've had to have some interaction with FEMA at some point. But a lot of the federal benefits flow from the Stafford Act, which by its very terms is designed to protect property and kind of foregrounds property-based responses to federally declared disasters. There's all kinds of, there's three primary types of assistance available: individual assistance, public assistance, and hazard mitigation assistance. And those are administered by a host of federal agencies, but predominantly by FEMA and HUD through community development block grants. And so we just kind of went through and looked at how historically a lot of these programs have been administered despite not having restrictions on focusing on renters, how they've been administered in a way that overwhelmingly benefits homeowners to the exclusion of renters. And that's not because of a disproportionate need. It's not because homeowners are impacted at a greater level than renters. In fact, oftentimes it's the converse, that renters in the wake of a disaster are facing greater need, and yet the majority of benefits are flowing to homeowners. And so some examples from this in the HUD Community Development Block Grant Disaster Recovery Program, of the $24.8 billion total spent on those programs, renters only accounted for 12% of allocated benefits, and in the past 10 years. And then in a review by the Government Accountability Office for post-Katrina spending in particular, $11 billion of those funds were allocated to homeowners, and only $1 billion went to renters. And so, yeah, just kind of try to highlight what this means on the ground, is that renters in the wake of federally declared disasters often are left without recourse to be made whole, to find alternative housing. Short-term housing often runs out quickly, and without a place to return home, there's no pressures for landlords to make repairs, and so renters are oftentimes left with little choice but to live in substandard housing or move in with family members, that type of thing. So we then got into looking at two state level case studies comparing Texas and New Jersey, because the state level responses obviously, and programs available, vary widely, and a lot of them kind of track landlord-tenant law. States that are more protective of tenants tend to have more affirmative measures in place for how to think about renters when it comes to disaster response, and affirmative programs for helping renters, whereas states that are more landlord protective tend to offer less for renters in the wake of disasters. So we looked at Texas after Hurricane Harvey, and there was overwhelming benefit distribution based on property owner status. And this was highlighted really effectively in a lawsuit brought in federal court, where renter status was used as a proxy for race. And essentially the claims made were that benefit distribution had a disproportionate impact on people of color because they overwhelmingly went to homeowners as opposed to renters. And so that case, I think, really carefully delineated how renter status can be a proxy for other kinds of discrimination, and why renters urgently need more focus in pre-disaster planning, so that after disasters, pre-existing inequalities aren't just replicated. And so after that suit, Texas hasn't made many substantial changes to its benefit distribution program. And after Harvey, there's been a lot of efforts to move people out of the floodplain and to relocate families that are currently living in areas that are really flood prone. And that community-based relocation, also known as managed retreat, is happening overwhelmingly and really only to with homeowners and not at all with renters. Whereas in New Jersey, after Sandy first in 2012, and then in Ida, there was, although initial benefit distribution overwhelmingly went to homeowners, there's been subsequent course correction and a lot more affirmative planning put in place for renters, including community-based relocation that actively takes into consideration how renters can be helped to move out of the floodplain, despite not being property owners. I'm gonna just speed this along so we can get to it. I'm realizing okay. And then another area that we looked at are local habitability programs, which are one way that local municipalities are starting to attend specifically to the needs of renters. So here in New Orleans, last year we passed the Healthy Homes Ordinance, which provides for a whole host of protections for renters, and including minimum standards for rental units like heating and cooling systems, proper roofs, windows, doors, and periodic inspections. And the reason that that policy is so important is because it ensures that people are living in climate safe housing in the first instance, so that when natural disasters come through and we get heat waves, they're able to stay in their homes and they aren't forced to relocate. And in Philadelphia, there's actually a landlord side program that's been funding a whole host of weatherization upgrades to affordable rental housing stock, and providing no interest loans to landlords to ensure that their units are more climate adaptable and safe. And in Philadelphia, one of the major threats that they're facing in certain neighborhoods are the heat islands and flooding. And so the efforts there are targeted at making sure that housing is more safe for tenants. And okay.
Oh, so this was our like wish list section of unrealistic hopes and dreams about what could happen if renters were prioritized in long-term climate change planning. I mean, there's so much already not done, and acknowledging and grasping and addressing and thinking strategically about long-term climate change impacts nationwide and locally and how we should address those. But specifically just thinking about renters and all the gaps that we saw in the existing sort of responses. I mean, honestly, all we need to do is build a lot of climate safe weatherized housing. And the one thing that we absolutely will not do is build a lot of climate safe weatherized housing. It's just not happening. And there's lots of reasons for that. But that's not what we're going to do. So we tried to think of things that might be still probably pie in the sky, but somewhat achievable. And just the idea of mandatory disclosure laws. I mean, a lot of times renters don't know the risks that they're renting into, so they don't necessarily understand evacuation risks, if they should be looking at specifically looking at insulated or air-conditioned units, if they should be staying out of basement units, if they should be purchasing flood insurance or renter's insurance, sorry. And so just a disclosure law would be very helpful and fairly simple in terms of implementing. And there is a reasonable amount of literature out there about how just more information will change risks. And just generally, like expanding that, normalizing the climate risk disclosures as part of any kind of property transaction. A lot is known, a lot is understood about climate risks and weather risks, and isn't necessarily shared. There's in emergency and disaster responses, direct payments have proven themselves to be useful over and over again. And so cities that have done direct payments across the board to all residents, regardless of whether or not they rent or own, follow-up studies have shown that those are across the board extremely helpful and successful. Nobody, and city governments hate them, state governments hate them. Nobody wants to hand out money without strings. So those are really hard to implement, but in an emergency situation, they have been found, at least in small scale, to be highly successful in helping people survive disasters. Tenant-focused habitability legislation and bills of rights for renters. Claire touched on that there are cities out there that are experimenting with specific renter-specific bills of rights. They tend to be mid-sized cities, and they tend to be it's all pretty new, but so far they seem to be fairly successful. And again, it kind of falls under the mandatory disclosure law situation, where it's just more information is better, more rights and more communication is better, and reduces risk just by renters being able to be treated better under the law and share information. Incentivizing landlords to weatherize. There are already really great incentivization programs out there, but they're not really being taken advantage of or used or implemented broadly. HUD has this great program, but HUD also has all this literature about like, why aren't the landlords taking advantage of this program? We don't know. So building out incentives or making them more attractive to landlords to weatherize their homes, that would actually prevent a lot of housing loss and a lot of interruption of income and all sorts of things for renters. in all kinds of environments across the country, but we just have to build in better incentives because the HUD program, while it appears on paper very positive, just hasn't been successful in getting much involvement. Repealing the Faircloth Amendment, which capped the nation's supply of public housing in 1999. 89. When was that? Whenever the Faircloth Amendment passed, that was a nationwide. Just we're not building anymore. The supply of public housing will stay at this number. That's a terrible idea. Everybody hates it. That's involved in housing advocacy. It seems to be across the board as we've learned more. And getting rid of that, I think, would be popular. But our twist on that would be supporting in additional housing building, but making sure that climate adaptations are built into any kind of new public housing projects. And in fact, as environmental lawyers, we really liked this last one about requiring climate planning in the permitting process. So HUD currently has, for federally funded housing development projects, you have to go through sort of the same kind of EA or EIS procedures that you would for like getting a clean water permit. So you have to, and they built into their environmental assessment part of the project permit application, you have to account for and explain how you're going to manage climate risk in your housing project. And if you don't do that adequately and you don't convince us, then we won't give you the money and the permit. And that's great. However, given the Faircloth Amendment and other things, there isn't a lot of HUD funded, federally run and developed housing projects under construction right now. So it's this great idea that isn't really used. But if we were to say encourage state and local governments to say, okay, any funding you're giving for housing developments and projects also has to include some sort of climate pre-building, pre-construction climate planning. So you understand the risk you're in, which makes sense because climate risks change so geographically. Your climate risk in the middle of Texas is not your climate risk in Miami. But nonetheless, the risks exist and are known and quantifiable and can be to a certain extent planned for now. The science and the data is mostly there. We're just sort of ignoring it and building without thinking. But if you built in that sort of process into a permitting process, I think that would go a long way.
Yeah. And I'll say there are some exciting roadmaps in that regard. There are some people who have put together some exciting roadmaps for envisioning kind of a transition to adaptable, like climate adapted and affordable housing, which is like the Green New Deal for public housing is a really great blueprint for that. And there's some wonderful resources out there. And the final thing, I know we're almost at time, we also discussed some possible litigation solutions under the Fair Housing Act. There's been some interesting litigation. The Wharton case, which I referenced earlier, which was filed in the Southern District of Texas after Harvey, is an interesting example of trying to use 3608E5 of the Fair Housing Act and the duty to affirmatively further fair housing. There are obvious barriers to Fair Housing Act claims, especially in the Fifth Circuit, where 3604A has been more narrowly interpreted to require constructive eviction if you're going to sue to enforce your right to housing under it, and then under B, potentially you'd have to a litigant would have to make a disparate impact. Make an intent showing, not just disparate impact. And so there are barriers there. And an interesting avenue that's widely underexplored, I think, also is 3608D, which requires a duty to affirmatively further fair housing on the part of all executive departments and agencies. So not just the HUD secretary. As a corollary to Fair Housing Act claims, one could also bring HUD complaints at the administrative level, and there, of course, disparate impact theories are available. And so those were some of the possible avenues that we kind of went into a bit further, but we are at time. Okay. Thank you. Sorry.
A couple minutes for questions.
Oh, yeah.
I hope you all help me if I ever venture into the environmental field. nothing.
Yeah.
I just wonder, I think the challenge here is you can't really get to equity, you can't get to climate without supply.
Mhm. Yeah.
And, after Katrina, we saw after disasters, everything you need, you're at a moment where your supply has been obliterated, and then even more restrictive zoning comes in.
Yeah.
And so, how do there's a lot of movement now in trying to counteract the large lot single family zoning, which is probably where the kind of zoning that exists in the places with the least climate risk.
Right.
I'm guessing. So do you think that there is some synergy between efforts to, let's say, allow more accessory unit development, allow 2 to 4 units on a formerly single family zone lot? And does that have implications for increasing supply for renters? Or do you think that's just going to take too long to create enough units to kind of make a difference? Because it is a very slow process.
Yeah.
Those kinds of measures.
I think, well, do you want to?
Oh, I was thinking, I think I would agree with the last part about it's just gonna take too long. There are, there's actually, I think it's a Yale clinic that's doing a lot of zoning litigation aimed at sort of this topic of this paper, but it takes forever. They take one case at a time, and maybe you'll get a couple extra units in New Haven somewhere someday, and that's about it. So I'm not sure if that's the way to go. I think that zoning changes do need to happen, and we kind of touch on that. And there are cities that are exploring this, but not enough, and not soon enough.
I think that's a really interesting idea, especially in like receiver communities, places that are going to be receiving a lot of people in the long term. And there is, I think it's Minneapolis actually just recently did away with single family zoning, and we touch upon that a little bit in the paper, how this is kind of maybe presents a roadmap for scaling up and creating new units.
The feds condition some of their post-disaster funding on zoning changes.
Yeah.
Receiver communities approaching things.
Yeah.
We won't hold up.
I think
that's a good.
we do kind of touch on the fact that receiver communities and the communities that are going to have to absorb all the people that are leaving the more climate affected community areas are just not addressed at all right now. And we're all just like, good luck, guys, go find your new house and like crowd, inland areas. And there's a lot of those communities are renter heavy communities and are going to be squeezed out because housing prices are going to skyrocket. There's all these like cascading things. And really, we should not have written this paper because there's just too much to do in the paper, in the page limit we had.
Yeah.
So
Yeah.
Yes. It's you, David.
So for the next paper, anyway, thanks for presenting this. Appreciate it. So my question is, it sounds like you're talking about really large scale developments that have to occur. And would there not be reasonableness involved in creating tax policy? Because at one time, urban development was really completely based on federal government, either matching funds or just seed money. And my own perspective is on the state level, we always incentivize the movie industry coming in. For every $100 of tax benefits we generate in Louisiana, $1 of revenue. So there's clearly no equity involved from the taxpayer's perspective in continuing to subsidize these limited ventures.
Yeah.
We also incentivize the creation of homes in the lower ninth ward. So Brad Pitt and Angelina Jolie got huge amounts of money in tax benefits. And yet today, less than 15 years, 12 years later, those houses are falling apart.
Yeah.
And it doesn't seem there's any accountability in terms of the quality of the construction. The third point is FEMA spent hundreds of millions of dollars on non-usable trailers that developed mold problems and were uninhabitable in less than a year.
Yeah.
Again, there seems to be less accountability here.
Yeah.
But is there room for an opportunity to address the issue on a more long-term basis if we use tax policy?
I think,
So that it's enforceable?
yeah.
So that if your buildings fall apart in less than 10 years, we're going to come back and we're going to reimpose whatever the benefits were that you were able to reap by virtue of our giving you the tax benefits.
Yeah, and I think there are actually a whole host of interlocking tax policies that are out there aimed at addressing some of this. We actually explicitly note that we didn't get into that in the paper, but I do think that you're spot on, and that's, would be an effective means for addressing.
when I suggested this topic to my editor for that journal, who edits environmental stuff, he's an environmental guy, he laughed at me. Actually, he laughed. He thought he was laughing with me. He thought I was joking. That it just sounded so trivial that we should regulate odors when there are all these pollutants that we're not regulating. And so I want to basically tell you what I told him, which is defend this idea that EPA should be regulating odors under the Clean Air Act. And basically, I'm going towards environmental justice. That so we start with so why regulate odors? And of course, first justification, which is fairly easy and really should be enough, is that odors really are a nuisance. Not necessarily for everybody. I mean, in my neighborhood, every now and then, you know, the wind's blowing wrong, but maybe that would not be enough to drive a need for regulation. But a lot of the people I used to represent who lived near fence line, near the fence lines of industrial facilities, they put up with an amazing amount. So it may not apply to everybody, but for some folks, it really impairs our quality of life. Second, and this is where we get into both the environmental justice and health protection justifications, odors are caused generally by chemical emissions, and many of those chemicals also pose health hazards. So when you reduce the chemicals that produce odors, you're also reducing chemicals that cause health problems. And then odor regulation would advance environmental justice because a lot of the place, I mean, most Clean Air Act regulation thinks in terms of ambient air. So basically the air everybody breathes. And to some extent, the people who are breathing air in hotspots get left out, right? So if odor is one way to identify those hotspots, so disproportionate impacts. So EPA's duty, why do I think EPA has a duty to do this? Part of what the Clean Air Act says is that EPA has a duty to protect the public welfare from any known or anticipated adverse effects. And then public welfare itself is defined, and that includes personal comfort and well-being. And in fact, the legislative history shows that when Congress enacted the act, Congress thought EPA was going to regulate odors. The system I'm talking about is called the criteria pollutant system. So when I say Congress expected criteria to be issued, when EPA issues criteria for a pollutant, it then has to regulate that pollutant. So Congress expected odors to be regulated. And then in the 77 amendments to the act, Congress specifically ordered EPA to evaluate whether or not it should set ambient standards for odors. And EPA evaluated it and said, not doing that, okay? So first of all, policy issue, which is I'm saying, hey, it's really enough that odors impair people's quality of life, but I'm also putting a lot of weight in public health, environmental justice. Is that an appropriate policy concern? So two examples of places where it's been argued that it's not an appropriate policy concern. Really what I'm talking about is it's collateral benefits or co-benefits or ancillary benefits. The idea being if I address one problem, I'm going to also address these other problems. And this was addressed once by the Clinton administration at EPA, and it was an environmental justice complaint for the Select Steel proposal. The thing was never built, but for other reasons, because what EPA said was, no, unless you violate one of our standards, there's not an adverse impact. And if there's not an adverse impact, there can't be a disproportionate impact. And I hope through the talk, you'll see why I think that's nonsense. And then more recently, the Trump administration, they were dealing with cost benefit and the idea of dropping out of the benefit equation all of the co-benefits reducing, so this was regulating hazardous air pollutants from coal-fired power plants called the mercury and air toxics rule. And so what EPA did in the cost benefit analysis was consider the fact that when you reduce mercury from coal-fired power plants, you also reduce particulate matter, you reduce ozone precursors, and a lot fewer people would be going to the hospital. And so the Trump administration's position was, no, that's already addressed in these other programs. Therefore, it's inappropriate to address them as co-benefits. Everybody with me? Complain if you're not. All right. Well, I mean, here's why I'm not. I think it's inappropriate to discount this the benefits of co-benefits. Is that these health protection programs are rife with gaps and limitations. The criteria pollutant, which is kind of the heart of the Clean Air Act, is a criteria pollutant program, and that's for ambient air, the air we breathe, not in here, because this is workplace air, but out there. Ambient air, only 6 pollutants are regulated. Now, they actually gather up a lot. We get a lot of mileage out of those 6 because the 6 include particulate matter, which includes a lot of stuff, right? Dangerous stuff. And also ozone, ground level ozone, which comes from interactions involving oxygen and volatile organic compounds and oxides of nitrogen. And therefore you end up regulating these precursor pollutants, but you're regulating them for their effect on ozone, also not, and therefore not for the specific dangers that come from these specific pollutants. Okay? Additionally, these standards are tough in that they're expensive to meet the standards. So even though Congress told EPA, don't consider cost when you set these, not when you set the welfare standards, when you set health standards. And there's been a lot of debate about whether or not that's absolutely crazy to make decisions without considering costs. But basically, everybody knows that EPA considers cost. To some degree, they have to, right? And so what that means is that, and you know, essentially, if you simply tighten down, say, the ozone standard, which, by the way, a lot of us aren't meeting already, that's a very slow way to get at some of the big polluters that maybe are also causing the odors. Are you with me? Okay. Okay. So, and Congress recognized this, by the way. I mean, Congress issued findings which said, for one program, saying, hey, we intend this program to protect the public, notwithstanding attainment of our national standards. And in legislative history, Congress basically said, yeah, there aren't even known thresholds for safety from any of these pollutants. So we know that these standards are not really fully protective. We've got a whole other program other than the ambient program. There's a hazardous air pollutant program, which is to protect us from hazardous air pollutants. It's emission standards rather than ambient air pollution standards. So one problem with it is you can have, you know, a facility is limited by the emission limit. If you've got 3 of them in your community, you've got 3 times the emission limit because it's not an ambient standard. There is a provision in the hazardous air pollutant for what they call a residual risk analysis. And so EPA goes back and potentially tightens up the regulations if there are residual risks. So for that purpose, EPA has defined safety, right, or defined risk. It's an ample margin of safety is the legal term. It's a term of art, right? And they've defined it as between 1 in a million and 1 in 10,000 excess cancers for carcinogens, right? So what does that mean? If there are 332 million people here in the US, then we're expecting 332 excess cancers, which is not really fair because that's assuming that everybody gets the maximum dose, which probably is happening, right? And similarly, if we go to the 1 in 10,000 into the range, which is still acceptable range, 33,200 excess cancers. And additionally, we just don't really know in terms of our risk assessment abilities, risk assessment science, how to deal with things like synergistic risks, So the synergy is a really popular word, right? It's such a great thing. And working together, we will do better things, synergistic impact, not so good in pollution. Because, so for example, asbestos workers who also smoke, their rate of cancer is higher than you would get if you just added up the risk from asbestos and the risk from smoking. Lack of monitoring is a huge problem in EPA's current program. And it kind of is often overlooked because we assume we know what we're talking about. In fact, I've talked to people in our economics department at Tulane, who've talked about, we use this EPA data. Yeah, the EPA data, it's not very good because it's mostly based on either estimates, right? Or it's based on what they call parametric monitoring. And the idea of parametric monitoring is you monitor other things which presumably tell you how much is coming out of the stack, which sounds great, but EPA doesn't necessarily insist on that linkage that would really prove that that's what's coming out of the stack. So what I'm saying is we don't really know what we're putting out there. Couple of examples. This was a case that upheld one of those residual risk analyses, and EPA had relied on 7-year-old results of an American Chemistry Council questionnaire filled out by member companies with a 44% response rate. And that was what EPA used to determine whether there was an ample margin of safety. I felt bad about complaining about this because, we're about to make decisions, I assume, on our climate survey, which is a 33% response rate. But what can you do? But there, EPA could have gotten data, right? And EPA explained to the court that reliance on industry sources is a well-established practice, and it would be costly and time-consuming to actually gather data. So, is it legal and politically feasible for EPA to set a welfare standard for odors? I mean, I have a hard time predicting what the U.S. Supreme Court's going to do next, right? But I want to say it's basically beyond dispute that EPA has legal authority to set an odor standard, major questions doctrine notwithstanding, right? Because the Act specifically says protect public welfare and specifically defines public welfare. And in fact, the legislative history assumed it was going to happen. So, also, though, it is in some ways a more practical standard than these health protection standards. Because one of the problems, or political problems anyway, with the health protection standards is once the agency sets a standard, it really gets locked in. The statute tells you, here's when your attainment date is, and here's what happens to states that don't come into attainment. And what happens to states that don't come into attainment, and there's all sorts of slippage in the system, and EPA not making findings it should, but nonetheless, basically, regulations get ratcheted down. Definitions of major source get reduced so that from state's point of view, it's like you're killing us, right? Our economic development is out the window, right? We're labeled non-attainment, and we've got more and more permitting standards. It's harder and harder to get a permit, more expensive. So these health protection standards are quite unpopular in terms of local politics. Now there's a secondary standard. The welfare standard is not bound by those same limits. So the automatic things don't happen to you if you miss your deadlines under the secondary standard. And in fact, the deadline for attainment is as expeditiously as practical. So in theory, at least, there should not be the same political blowback that EPA gets, for example, for reducing, as it tends to do, right? As science gets better and better, the ozone standard tends to get tightened up through the years, and people scream, about job killing. And EPA, of course, responds. We're not allowed to consider costs, right? And then so legally, yes, I'm confident within my extremely poor track record of predicting the future that it would be legal. Is it practical? It's more difficult. Well, I mean, we monitor very poorly anyway, but it's, you know, it's a little bit more difficult to monitor odors. Now we do in environmental law use narrative standards, right? One court compared narrative standards to a speed limit sign, which says, don't drive too fast, right? So, I mean, so there's Virginia standard, Virginia administration, so part of, you know, people are doing this, right? States are doing it, local governments are doing it. No one or other person shall cause a permit to be or shall cause or permit discharges that cause an odor objectionable to individuals of ordinary sensibility. That's got enforcement problems, but nonetheless, it's got, you know, it could be enforced. Narrative standards are enforced, not as well as numeric standards. There are potential numeric standards, and a lot of these can rely on things like train people, right, who use these this equipment that dilutes odors. So you can do things like figure out this is what can we detect after the odor's been diluted 7 times. So what I'm saying is it can be done. Also options are using circuits, right? So you've got you know, 30 parts per billion. Basically, when people start complaining about hydrogen sulfide smells, and like all monitoring technology, it's getting better. People are working on this electronic nose idea. So I think if EPA were to take this step and create the standards, that would inspire even more progress. But I mean, right now it's practical to do things, and the agency should be doing it. So no panaceas, right? I'm not saying this will solve everything. And the fact that there's no specific deadline makes it less scary for EPA, not as much political blowback, and of course, that much more frustrating, you know, from somebody who's trying to enforce it or use it to improve things in communities, but gives you something, right? It gives you a handle that right now we don't have, especially given the fact that there's no specific environmental justice legislation out there at all, right? So this is a way to target people or target areas that are suffering under current law. And I think that's the gist. So I think I've got a few minutes for questions.
Really an observation, I'm not sure where you take it, but I once worked for a planning firm that mapped the city of New Orleans in a lot of different overlays. One of them was smell zones. Architect Ronnie Katz, an urban planner. And it was sort of the opposite end of what you've been describing. It was coffee roasting or bread baking. The notion was that if we're going to, with a housing preservation study, if we're going to preserve certain things, we ought to be sensitive to smell zones. So, I don't know, if urban planning spent more time looking at smells and odors, maybe it would make people more aware of it.
Okay. Yeah.
So this is making me think that maybe the EPA is not the right vehicle for odors. And so I was thinking, I mean, just, I understand your, like, best case scenario, this is what they can do. What about just like class action private nuisance cases involving odors?
Well, there is litigation involving odors.
Yeah, so I would love to hear, I mean, I don't know about this, but I'd love to hear in terms of like, because the Virginia statute you showed looked a lot more like a tort standard, like a reasonable person smelling this air, and then you can avoid all these metrics by saying like, because it becomes a lot more subjective, like the neighbors don't go outside, they don't let their kids play outside because it smells so bad, they can't sell their house because it smells so bad, it becomes this very like qualitative as opposed to how you quantify odor. So like, is that almost, given that the EPA is such a tricky vehicle, like, would it be better just to keep bringing private nuisance suits?
Well, but that's not going to improve the situation because that's what we're doing now. I mean, EPA is a tricky vehicle because government's a tricky vehicle, right? And I mean, my libertarian friends tell me, oh, the common law tort system should fix everything. You could say that about any pollution problem. It doesn't, right? Yes, there are some lawsuits. They're expensive lawsuits, right? Do you get the payback? Is that the most attractive lawsuit that that a plaintiff's firm is going to fund and take? In that print out the article, there is a guy who teaches in our environmental program online who wrote a one-pager about, hey, here's what's going on already in terms of tort law. But I mean, so far that has not been the solution. And so I want a regulatory handle. And I think once I've got a regulatory handle, over time, that handle will become more and more useful. Okay, thank you.
So I don't want to, so I've been having this for a long time, this insight and this intuition that maybe paid work is not the most liberating thing that we can do with our lives. And this is an insight that Black women have long held dear to themselves, right? During the women's movement in the 19th century and in the 20th century, when other women wanted access to, when white women wanted access to the professions and access to work, what Black women really wanted was to take care of their families and stay home, right? And this was a struggle in the welfare movement and et cetera. And so what I'm doing right now is a long part of kind of like Black feminist tradition in thinking about what is the path toward liberation and where should we direct our scholarly energies and our advocacy energies. And I'm here to convince you today, well, maybe I won't convince you, but that's all right, I don't care. You know, I'm here to at least talk to you today about how I think that a lot of times we spend on the left way too much time trying to tweak anti-discrimination law and trying to tweak employment law and trying to tweak labor law so more people have access to work and so that work is more dignified. But maybe we should be focusing on something different, right? That the liberatory potential of the right not to work, the right to disentangle subsistence and existence from paid market work and from the discipline of paid market work and the extractive nature of paid market work is what we should be thinking about. So I'm using anti-discrimination law and the struggle to expand accommodation as a site to analyze this and think about it. But I wanted to put it in this larger literature. And I also want to put this in front of it. One of the things I've been doing lately, I have this little like tool, I have this little timer in my office, like a little Pomodoro, it's a little tomato. And I've been telling my students, I looked at Elon Musk's robot the other day. You know what the robot was doing? Elon Musk has his Optimus 2 robot. The robot was doing this, right? With an A. Now, I know that doesn't seem like a big thing. I'm doing it. I'm not that smart and I'm doing it, right? But to get a robot to do that with finger pads and all the programming, the AI, I was floored, right? First of all, I was floored because my husband said there's some guy who wants to have sex with that thing. I'm like, really, for me? Stop talking about the robot that way. That's the one thing I was very troubled about, right? Is that people see that robot and think of sex. I'm just like, oh gosh. But the other thing I'm troubled by is that it takes a lot to do this, but it makes us obsolete in some ways. It makes us obsolete in a lot of ways. And so, you know, you've seen this robot and you've seen the discussions about AI and how AI is coming for our jobs. We need to really start thinking about what life looks like when we are obsolete in terms of paid work. We need to start thinking about what life looks like, especially at the law school, when we need fewer lawyers. We need to start thinking about that. And so I'm going to come with me if you want to live. I always feel like that's the secret thesis of every talk I give. I think that we need to listen to what Black women have told us. Maybe the path to liberation is not through paid work. And so I have this little piece. I'm calling it, it's kind of a duology. I write things in duologies. It's called Beyond the Accommodation Revolution, The Right Not to Work. So it's introduction, argument, give you some background, do some things. But what I want us to do is reconsider the central nature of paid work and our efforts to examine the good life, think about liberation, and think about this in the sight of accommodation as it exists now. And I want to get you to think about what would a right not to work look like? What would that look like? And what the potential liberation value of paid work actually is, and where we should put our efforts in terms of movement building and advocacy and scholarship. So I kind of have two pieces embedded in this one workshop. I have kind of a more descriptive piece that's a more mainstream kind of law review kind of thought. about the right to work and using accommodation as a tool to expand the right to work in anti-discrimination law. And my thesis there is that one of the things that's happened is that there has been an accommodation revolution in anti-discrimination law. And I'll talk more about this in depth, but accommodation is, this small piece of how the ADA creates access for disabled people. And historically, the logic of accommodation wasn't a big part of anti-discrimination law outside of the Title VII context. And I'm going to talk about what that looks like. But all of a sudden, we have had this expansion of accommodation. And what I mean by that is that employers now have to accommodate things that employees want to do that they did not have to accommodate before. And it looks very differently, and I'll show you a map out how that looks. But we've had an accommodation revolution in terms of anti-discrimination law, in terms of work law. Actually, it impacts employment law as well, where the logic of accommodation in the ADA has actually expanded into other spaces. And to be fair, advocates have spent a long time doing that, right? A long time arguing that we should have accommodation in the PDA, that we should accommodate marijuana, that we should accommodate breastfeed, like all these things that we should accommodate. That logic is here, but maybe it's crap, right? Maybe we should have focused somewhere else, because I think that there's something else going on with the extractive nature of racial capitalism and what productivism demands. And so this is also a little bit of a meditation on racial capitalism as well. And that's why I started with the insights of Black women and what Black women have been asking for. Right, I'm alternative, the wages of accommodation, against accommodation. These are some alternate titles, meditation on productivism, racial capitalism, and law. But I'm trying to do a lot of things in a little time, but so let's go, right? One of the things to know is that anti-discrimination law has been wildly successful in the United States. It has been wildly successful in expanding access to paid work for a lot of people, right? Think about, for example, the existence of pregnant employees in the workplace, right? It ain't no thing when all of us walked around here pregnant, wearing kind of weird maternity clothes. That did not happen before the PDA was passed in 1978, right? So pregnant women, when they started to show, were just terminated. They were terminated from schools, they were terminated from secretarial positions, they didn't have access to law firms at the time, but now, right, pregnant women have access to work. That's very successful. We've changed the culture. African Americans didn't have access to certain jobs. People with disabilities didn't have access to work. It was perfectly legal kind of to terminate people once they got older, right? We just read a case in my employment law class called Fortune versus National Cash Register Incorporated. And in that case, the interesting thing is that the gentleman was basically terminated because he was old, but it was just on that threshold of the ADEA. And so one of the questions we always talk about is like, well, why didn't he sue for age discrimination? Well, it wasn't really a thing, right? There wasn't good education, but expansion to paid work through anti-discrimination law has been very successful, and scholars have devoted a lot of time to doing that. It's expanded access to paid work in very many professions to women, people, colored people with disabilities. But I'm always troubled by paid work, right? I don't think paid work is the path to liberation. And there's a larger racial capitalism literature that talks about this, but I want to put that to a side because one of the things that has happened in anti-discrimination law that I want to prove to you, and I might just get through this today and talk to you about it, is that there's been an accommodation revolution, right? But the problem is that the promise of accommodation has kind of been limited. And so just as a footnote, understand that as we've expanded accommodation in Title VII, in terms of thinking about the right to use medical marijuana or recreational marijuana, the right for Black women to wear their hair in the workplace, I'm going to talk all about this in a minute, accommodation, even for people with disabilities, has been critiqued. And a lot of people with disabilities have shifted from advocating not to accommodation, but to something else. And one of the problems with accommodation under the ADA is that accommodation, for people with disabilities is a reasonable accommodation. This privileges certain employer preferences. Employers are allowed to determine what a job description says. Employers, when they make accommodations, the accommodations must be reasonable in nature. What does it mean for an accommodation to be reasonable, right, is often a discussion. And, I think the other limit of accommodation in the context for people with disabilities and advocates of this body of law is that it forces employers to internalize costs. You can think about, global north countries like the Netherlands or other countries where, whenever somebody needs an accommodation, the state plays a larger role in assisting workplaces and assisting employers in making that accommodation a reality. Here in the United States, accommodations are in part dependent upon the resources of the employer. So for a big, sophisticated employer like Tulane, there's a lot of accommodations available. People can access many things. If you have a smaller nonprofit that is covered by the ADA, but has limited resources, it's not as reasonable to ask for the same kind of accommodations that Tulane would get. And so there are limits. It's one of these things where you don't, you could try to choose a larger employer, but if you are, a lawyer, for example, in our clinic versus a lawyer in some other nonprofit, the access to accommodations that you'll have is dependent upon your employer. What is reasonable is situational. And people with disabilities have said, that's not good, right? It's not good in part because we can't access certain accommodations we need. And also accommodation treats people without disabilities as the default reference point. And I think that's been critiqued. But the thing about accommodation under the ADA is that it's been really radical, really revolutionary. It's changed the ground upon which we walk. People with disabilities are now included in ways that they were not included before. But also, accommodation's been kind of reductive, and it's a concession to the status quo. Why is it a concession to the status quo? Because the principle of accommodation, which is designed to increase access to paid work, still takes paid work as something that everybody should do. Paid work is the default of existence. Paid work is the default of citizenship. So I think it's paradoxical, right? It's simultaneously a concession to the status quo and a radical revolutionary move for expansion. So a lot of people with disabilities and advocates in this field have shifted toward other kinds of reforms like universal design. And to illustrate universal design, people talk a lot about the pandemic when we were all allowed to work from home. Working from home and engaging in remote work increased opportunities for people with disabilities, but also increased opportunities for people who had compromised immune system, increased opportunities for people who had elder care obligations, increased, that it served a lot of different people without carving out saying this is particularly for people with disabilities. And it was, remote work was a universal design for safety and had some positive consequences during COVID-19. And people look at that moment and say, there's something beyond accommodation we could do with universal design in terms of law, in terms of policy that may be productive. But, accommodation is still a really, really important thing, right? I feel like, I'm already running out of time. The Americans with Disability Act, right, requires reasonable accommodations. Individuals who are qualified, right, qualified individuals with a disability are entitled to an accommodation, and covered entities have to provide these accommodations. Accommodations, as I said, must be reasonable. And in order for an individual to be qualified, they have to perform the essential job functions of the role with or without an accommodation. Accommodations are created through an interactive process, meaning that the employer and the employee work together to figure out what accommodations should be. Right, so this is like background information. But accommodations have historically not been a big aspect of Title VII or other aspects of work law. So, there was a limited right to accommodation for individuals when it comes to religious practice, but when it comes to race or gender, oftentimes employers were not required to accommodate individuals. But I think that this has shifted, and I want to talk to you about how the logic of accommodation has come to animate work law beyond the Americans with Disabilities Act, right? So, one of the big parts of what I've been doing and working on and thinking about is how the logic of accommodation
animates work law generally and anti-discrimination law specifically in places that it didn't. And there's a few different things I want to talk about. One is the PUMP Act, right? Providing urgent maternal protections for nursing mothers. The other is the Pregnant Worker Fairness Act, and the regs just came out on that this week, and we'll talk about that. The other is the Supreme Court expanded protections for religious individuals in Groff versus DeJoy last summer under Title VII. And the other is the Crown Act, right? We could also have a discussion if we had time about recreational marijuana, right? I love to talk about recreational marijuana, right? And maybe if we'll have time, we'll talk about that too. But these are some of the places where there weren't accommodations for employees before. But now accommodations have expanded into the realm of anti-discrimination law and work law in some new ways, right? Now, oh my gosh, but Tominal did put marks up there. Yes, she did, of course. So against this, you know, I'm going to talk about the expansion of accommodation. But one of the reasons why I'm really worried about paid work is because one of the things that troubles me about paid work as a path toward liberation and inclusion for everybody, not just people with disabilities, but also for everybody in this room, is that when it comes to paid work, we kind of all are Marxists. We all agree that paid work is essential for our species being. It gives us belonging. I recently read this essay by Eric Posner, right? Eric Posner had this essay, and he's like, what are we going to do? Because we can't replace paid work as a mechanism for belonging and citizenship with anything else. There's nothing else we can replace it with. How will people belong? What will they do with their lives? I'm like, as Black women, right? There's plenty we could do beyond paid work. It's interesting that law professors often can't imagine a life without paid work. We love our work so much, right? We do, we really do. So puzzle for you. What do Republicans, socialists, and Catholic saints all agree on? If a man shall not work, neither shall he eat. Right? Lenin, St. Paul, and some Republican congressmen. You remember, if a man shall not work, neither shall he eat, right? They're quoting this. They all agree, right? That subsistence and existence should be linked to paid work, right? Democrats, President Biden often talks about the dignity and beauty of paid work, and his mechanism for making it fair is unions. And he's not alone, right? Left legal feminists across the spectrum also agree, right? So these are both people on the left. One is Marxist feminist scholar Silvia Federici, right? Silvia Federici was one of the organizers for something called the Wages for Housework campaign, right? And that was the idea that the problem with housework is not that we should have a robot do it, right? The problem with housework, you know, scrubbing and cleaning and changing diapers and doing dishes, the problem is not that women do it even, the problem is that we don't pay women for it. That if we paid people for it, it would be more dignified, right? And it's similar to something that Vicki Schultz argued in The Life's Work, where she discussed in this article, this kind of like paradigmatic article, she discusses how, you know, everybody should have a life's work, and some people's life's work will probably be like taking care of infants, right? Or cleaning up dishes or taking care of garbage. Of course, it should be dignified, but one of her main arguments is that we need to externalize housework to the marketplace, that we shouldn't be doing it in a private context. We shouldn't be cooking in a private context. All that stuff should be externalized and should pay people to do it, right? And I'm like, it's very interesting that law professors are arguing that there should be dignity in collecting garbage, right? That this is your life's work to collect garbage, right? It's always, she got skewered for it, right? But it's a very interesting thing that there's not much that Silvia Federici and, you know, Vicki Schultz would agree about. But one of the things they agree about is that we should use the market to talk about housework, right? And we should pay people. So I'm really troubled by this, right? I'm really troubled by how accommodation law and anti-discrimination law and work law serves racial capitalism, serves extractive notions of productivism, you know, and how it requires that everybody has a job and that everybody gets some kind of paid work going. And so part of what I'm struggling with, you know, is what, you know, does accommodation serve racial capitalism? How, and there's an entire literature on this that I've written in myself. But also, you know, at a place like Tulane, is paid market work an environmental and social death cult. There's a scholar in critical race theory, Anthony Farley, and he loves to talk about death cults. Like it's one thing, like it's one of his main things. Like if you say like there's something that Republicans have done, he'll say death cult, right? That's what he says. But on some level, like this idea that we constantly have to have growth, we constantly have to be consuming, we constantly have to be producing, there constantly has to be more lawyers, there constantly has to be more student loans. We have to have more and more and more and more. In an environmental context, is kind of troubling, right? And so I think that this is kind of background to why I'm so worried, but I'd also want to say, like, I'm coming at this from the left. I think people should have accommodations. I'm very happy to accommodate people. Accommodation is an important form of harm reduction, but is it actually the way to liberation? I don't know, right? There's other forms. But I want to go back and talk about some of the expansion of accommodation, right? You know, this is the trouble with this is a big project and it's actually 2 articles. So there are these different laws that have passed that incorporate the logic of accommodation into anti-discrimination law in places that it wasn't before. And so I want to explain a little bit more about this, now that I've kind of given you the thesis of what the larger project is going for. One is the Pump Act. So what does the Pump Act do? It requires employers to accommodate expression of breast milk in the workplace, right? Employers under the Pump Act, and the Pump Act was passed in 2022 as part of an omnibus legislation by Congress to expand the Fair Labor Standards Act's existing protections for individuals who are expressing breast milk in the workplace. It provides a cause of action to women who are women and also other individuals, although it specifically says maternal. So I always have questions about, like, what does Congress mean by that? Expressing breast milk at work. It builds on the Fair Labor Standards Act requirement that people have to have a private space with a door that closes and be given reasonable break time. What the Pump Act effectively does is give people a cause of action to enforce that. When the Affordable Care Act passed regulations requiring employers to permit expressing breast milk in the workplace, what they forgot to add was actually a cause of action. So people were trying to sue under the Department of Labor, and the courts were saying, there's no cause of action, go away, we don't know what to do. But the Pump Act requires employers to accommodate breastfeeding, right? Pregnant Worker Fairness Act built on the Pregnancy Discrimination Act of 1978. The Pregnancy Discrimination Act, one of the big pieces of challenge as part of the Pregnancy Discrimination Act is that it didn't require employers to accommodate any of the limitations of pregnancy in the workplace. And so, you know, women would get to a certain stage and they'd be like, well, I can't lift this, or I need water breaks, I need a bathroom, I need a stool to sit on at the cash register when I'm working at Walmart. And the employer would say, pound sand, right? The Pregnancy Discrimination Act doesn't require me to give you anything, right? And there's a famous case, Treat versus May department store, where a woman is late all the time in the workplace from morning sickness, and Judge Posner of the 7th Circuit said, you know, the Pregnancy Discrimination Act doesn't require you to accommodate anybody. And this kind of melted with Young versus UPS, but the Pregnant Worker Fairness Act, as part of the omnibus legislation in 2022 that also passed the Pump Act, requires employers to provide a reasonable accommodation for pregnant women in the workplace if they're limited in their ability to work. It also requires that the accommodation be given temporarily, even if people can't meet essential job functions. And the regulations for that just came out, right? Groff versus DeJoy, the Supreme Court case, expanded accommodations for religious employees. And what it did was, historically under Title VII, religious employees have had a right to accommodations. When an employer practice burdens exercise in the Title VII context, employees can ask for a reasonable accommodation, but the employer could reject that accommodation if it imposed a de minimis burden upon the employer. Now, the Supreme Court in Groff versus DeJoy changed that to make the employer's ability to reject these accommodations based on a substantial burden, right? So employers may only reject religious accommodations in the interactive process if they impose a substantial burden on the employer. And finally, the Crown Act, right? The Crown Act, to me, is interesting. People don't often think about it as accommodating, but under personal appearance policies and Title VII, we've historically allowed employers to dictate how people should look in the workplace. And this involved a lot of cases where Black women were told they had to change their hair, right? You can't wear braids, you can't wear locks. You can't wear a fade, you can't wear a natural. Black women also were not allowed to dye their hair blonde or red. The Crown Act, which is an act, it's pioneered actually by an alumni of ours, Wendy Green. She is one of the architects of it, requires employers within the states to accommodate natural hair in the workplace for their personal appearance policies. So there's also, and just as final thing, is another place where accommodation has been required is around the use of recreational marijuana. In states like California and New York, there have been given protections to employees who use legal substances, i.e. marijuana, in the workplace, that employers cannot discriminate against them on the basis of that use. They have to be accommodated. So what I'm kind of saying, we spend a lot of time getting these accommodations for people, and I'm not so sure it's a good thing. Because what we're doing is actually expanding who has access to paid work. And if the robots take our paid work, what do we do next? Eric Posner certainly doesn't know, and I don't know, but I want to imagine a life beyond there, and I'm going to put this slide up. So you're like, what do we do if we don't have paid work? Yeah, well, let's expand the welfare state of basic income. We could make Medicare, Medicaid, other things, Social Security, more expansive. We could collective forms of living. There's always jokes among my students about living in large polycules. If you don't know what a polycule is, you could ask me in the Q&A, right? Large groups and mutual aid, right? Sharing resources. And I can talk more about any of these things, but that's my quick and dirty. Thank you guys so much for listening. Different kind of project. I'm happy to talk more. Maybe feel bad now for answer questions. No comments, questions? Yay! Oh, everyone. Go ahead.
It seems like the common denominator here is really work or choice. Like choice. So like,
yeah, absolutely.
Like free will, the idea of free will is like 19th century underlying idea of what it is to contract labor kind of thing, right? So, but if you think about like, free will to pursue one's vision of the good life, that may be work. If you're a law professor, it may be work with accommodations, or it may be not work, right? Not to work and to be an artist, right? And not to worry about making.
Well, art is work, so I want to push back against that.
Right, paid work, paid work. Yeah, you might just want to paint your landscapes, and you don't care if you're getting paid for it or what, right? So it seems like maybe thinking about this in terms of like, we need a panoply of more choice in terms of how we pursue the good life, as bringing the accommodations and the not working together. I don't know. What do you think of that? Just
sure. I mean, I think that right now the only choice for citizenship, welfare, and subsistence is paid work, right? And we doubled down on that in the wake of eliminating things like TANF, right? Or creating TANF and eliminating age-dependent families with children, other forms of workfare, right? What critical cognition is called workfare. I am arguing for one, right? But I'm trying to argue for a world where we may not have more choices, right? Where the choice might be, we're going to have to figure out how people are going to live if they can't get paid work. Right now, one of the things we do with people who are on the lower end of the paid work spectrum, and this is part of the racial capitalism literature, they talk about sacrifice zones and environmental law, but they also talk about warehousing people in prisons and refugee camps, right? We have this surplus labor problem, right? Another place we warehouse people, I know this, I shouldn't say this, but I'm going to say it because it's a dangerous moment to report me. Another place we warehouse people, young people, is universities. If young people did not go to college and they flooded the labor market, we would have lots and lots of surplus labor. Lots of surplus labor. We warehouse people for years in universities. We warehouse people for years in prisons. Our unemployment numbers don't account of that, right? So we're already forcing some people out of the paid work marketplace and into other alternative spaces, right? And I don't think they have a choice. I don't think people feel like they have a choice about those things. I'm actually for more choice. I'm not against people with disabilities having access. I'm just saying we spent a long time on the left trying to tweak paid work into something liberatory when I'm not sure it ever was or ever would be. And had we listened to Black women at the start, which may have been the theme, maybe, I don't of some of the stuff that's going on, we might have had a different path. In terms of the social movements, but that's a whole nother thing. Thank you guys for listening.
Yeah,